Mr. Counsel, yesterday,
We realized that there's a technical clearing up in this motion. Well, what are the technical aspect?
not a technical aspect. It goes to the root of the matter. So,
Oh, I heard that one of the next one of the continuing the law to find additional affidavit on the receipts of the division of.
there is one more mistake.
What?
In the Wakalatnama,
What?
there is no endorsement of the jailer.
What?
Okay.
So I read that one of the next one of the continuing the law to find additional affidavit on the receipts of the division.
By what time?
Yeah. Yes, sir.
Mr. P. Seri, learned counsel for the petitioner, has sought for leave to file an additional affidavit through the next print of the detainee. Post of Mr. J. N. Guli, learned Central Government Counsel, and Mr. T. K. Angami, learned public prosecutor for the state of Nagaland, are present. Post of the leave sought for is allowed. Post of as the learned counsel for the petitioner has submitted that he will the additional affidavit by tomorrow. Lays the case on Thursday.
For admission, item number 2.
May it please your lordship. I am doing this matter through VC. So this was fixed today. The matter relates to your lordship. It's a habeas corpus, and we are challenging the preventive detention of the petitioner's husband under the PIT NDPS Act, your lordship. First, your lordship, I'll take your lordship to
Mr.
the
Mannan,
yes.
do you have a copy of the petition with you?
Yes, I have a copy.
See the affidavit. Page 13.
Yes, your lordship.
The previous case was same. The detainee has filed a sworn affidavit.
No, the detainee's wife filed the affidavit.
1 minute. Who is the
Rita
detainee?
Chatri filed the affidavit.
You can't go. Huh? Detainee Belai. You can't know.
Page 13, the Srimati Rita Chetri filed the affidavit.
Karan nama. Karan nama. Yes. No, iko jail ko. Ei detainee no. Ilo detainee mes jail ko se. Yes.
Yeah. So I'll take your lordship to
Okay. I think that
take your lordship to page.
1 minute.
it is coming from society. Last extension ended on 4/12/2024. And the challenge is put to against 35 other 35/2024.
Now, have you extended it?
The case you brought is with me and I must discussion on that.
So that means he's out.
I have not discussed.
Mr. Manan,
Lordship.
last order for extension was up to 4/12/2024.
Lordship.
So any further extension, do you aware? Are you
Uh,
aware?
They in fact I was challenging the initial case, and then they have given it up to 412, but the earlier also they have extended it. I don't know whether they have extended it on 4th or not. That in fact, I don't have the instruction on that.
Mr. Angami, you are in best position.
The
to apprise
party
this.
would be in a better position to state, Your Lordship.
Otherwise, the challenge is only against the original first election order, not confirmation or the subsequence.
I think.
In fact, the initial order was, there was no specific date given in the initial order.
3 months. It's always 3 months.
Can you find out whether it is extended?
So it was initially, it was for 3 months. Then they again extended it, Your Lordship.
But there was no challenge. Extension was no challenge.
No, extension part was subsequently done, Your Lordship. Initial, we have already challenged the initial initiation of the whole detention order. So if that is there, then obviously if they have already withdrawn it or have not extended it and the person has been released, then nothing remains. That is a different issue, Your Lordship. But as far the challenge is concerned, we have challenged the basis of the preventive detention itself.
Manan, did you file any representation?
There was no representation from the petitioner in this case, Your Lordship. I have stated in the affidavit that initially I was not informed about it, but they have stated that they have informed. But the petitioner, on the other hand, we have stated that all the documents, those were required for filing, or the person was not in a position to file a representation because he is in jail in Kohima, whereas his family is in Assam. So there are some difficulties for him to file. That is admitted fact, Your Lordship. Then second part we have taken was the whole dossier with regard to the preventive detention, on which basis of which he has been detained, have in fact not been given. That is a part which we are taking it as a as a one of the grounds. But considering the above, Your Lordship, the whole Your Lordship, in this case, the representation was not given with regard to the detention. But I am actually challenging on a few points. Apart from that, the grounds which were given to me for detention, the first ground that was given is which I am challenging. That is that since this person may be released on bail, if he is in the case, there is only one case referred to in the detention order. And
It was commercial quantity or what?
oh, no, it was a quantity below commercial quantity. It was below commercial quantity. That is why Your Lordship will kindly take up the grounds of detention for a moment. That is at page 14, 1-4. তুমি এবাৰ খবৰ কৰাচোন এই মানুহজনৰ ৰিলিজ হ'ল নেকি Your Lordship, I'll just read that. In the instant case, you so and so have admitted to illegal trafficking of narcotic drugs and psychotropic substance, marketing the same in and around Dimarpur town, thus conforming to acts under section so and so of PIT and DPS Act. That the state of Nagaland lies within the highly vulnerable to such illicit traffic of narcotic drugs and psychotropic substance as mentioned under section so and so of PIT and DPS Act. It is pertinent to mention here that you have admitted that the seized contraband was received from 6 Mile so and so, and the earlier consignment was sold in Assam, indicating that there is an interstate linkage spreading across the states of Nagaland and Assam. Now, next, number 3, that you are presently under judicial remand and likely to get bail if not preventively detained. On the basis of materials placed before me, I am satisfied that you are likely to indulge in similar prejudicial activity unless you are prevented from doing so by an appropriate order of preventive detention, thereby endangering lives of innocents and peaceful existence of citizens, and may warrant law and order problems in the state. Your detention will immobilize you from engaging in any kind of illicit traffic in narcotic drugs and psychotropic substances. That there has been a huge public outcry concerning traffic of illicit drug in the state, which has caused problems of abuse and addiction of all age groups, especially that of teenage school children. It is suspected that you are directly involved in intra and interstate network of smuggling and trafficking of illicit drugs, whereby luring youngsters to addiction and resulting in becoming peddlers. So kindly take up
Mr.
a,
Manan, let us have the information whether you are out or not.
yes, yes.
Then only you can proceed.
I have asked my junior to at least contact whether what has happened, Your Lordship.
We are requesting public prosecutor.
Yes, I am also trying to get through my possibly my from my time if possible. Your Lordship.
Thursday. We'll take up the matter on Thursday again. In the meantime, whether there was further extension or not.
Thursday, Lordship, I have some difficulty. Can it be either tomorrow or after some time, if possible? Your Lordship?
Tomorrow?
Tomorrow.
Tomorrow, I don't get enough information too, because so many cases listed.
No, this is only information to get whether
Whether
extension was
there's
made
been
or not
extension.
made. Extension was made or not made. That's all.
If extension is made, Your Lordship, I'll argue, and if it is not made, Your Lordship, then so he is otherwise released, Your Lordship.
Heard Mr. Y.S. Mannan, learned counsel for the petition, and Mr. K. Angami, learned public prosecutor for the state. Post of Mr. Angami has placed a confirmation order dated 30/8/2024, whereby, the detention of the petitioner was extended for further 3 months with effect from 5/9/2024 to 4/12/2024. Full stop. As the Mr. Learned Public Prosecutors has obtained instruction by tomorrow as to whether the period of detention has been extended, of the petitioner has been extended beyond 4/2/2024 by any other order. Lays the case tomorrow.
Much obliged.
For admission, item number 3.
Yes.
My lord, I have not definitely thought on my mind. My lord, the petitioner hearing is seeking for revocation of the
Yes, yes, Mr. Anguli.
My lord, I have my thought on the police to tell you in the street, but still I cannot sit there. That Congress.
Yes,
My lords.
The council, we are in a preventive detention matters. So the question of the notice was issued as far back as on 16/10. 2 months have gone by. One day of counter, it has been various judgments of the Supreme Court that you are to take these matters on an urgency. So we can't wait for that. If you fail to file it, we'll have to construe to that effect that we will not file. But the center has nothing to say.
His lordships.
And it was observed on 13/11/2024. If the affidavit in opposition is not filed by the next date of listing, the petition shall be proceeded in accordance with law.
Yes, Master.
State has filed. State has filed.
Lordships,
Yes.
Secretary hearing seeking for revocation of the detention order dated 4/7/2024. And there's subsequent confirmation order dated 7/10/2024. Well, the brief gist of the case is that a sumoto FIR was filed dated 11/05/2024, stating that during routine checking between Bisema and Kuzama village. and vehicle-
Let us read the Somuta FIR.
The page number of it. I have the honor to state that on 11/05/2024, self along with the following accompanying staff were detailed for MVCP duty at NH2 in between Kuzama and Bisema near Green Road, Kuzama village area. At around 7 AM, one Maruti Brezza SUV BR number so and so coming from Manipur side was made to stop for routine checking. There were two occupants in the vehicle, namely Karsin, represented Dinu, and Ms. Singh. Upon inspecting the vehicle, the duty party detected suspicious, specially built heavy chamber in the running board of the vehicle. And on closer inspection, the chamber narcotic drugs suspected to be opium were found inside the chamber. Accordingly, information was immediately given to the superior officers, SP, NNP, who also arrived at the scene, independent witness, namely Norfolk officer from the district administration, and three Catford Veho, BCM, Kuzama, were also called to the scene to conduct thorough search and seizure. The vehicle was inspected in presence of the above-stated witness and police officers. During search of the vehicle, 30 pickets suspected to be containing opium. This is 15 pickets each.
NDPS,
each running board
NDPS.
of the vehicle were recovered. The suspected narcotic drugs PM were taken out, weighed separately, and total weight approximately 31 kilos, 213 grams. And releases, which was recorded under videography. The drugs were then serially marked, packed, and sealed, which were attested by the independent witness in the accused. Other sister items are as for the mobiles, and after completion of all necessary formalities at the spot, the accused persons along with the 6 items in the vehicle were produced at narcotic PSPHQ on 11/05/2024 at around 2:30 PM. The original case was registered. Case on the relevant section of NDPS mechanically registered for the against the accused persons for further investigation. People arrested on 11/05/2024.
It was commercial.
Yes, ma'am. Thereafter, the additional Director General of Police, Law and Order, and Chairman of the Screening Board, NDPS, the peak NDPS, Nagaland, Kohima, by letter dated 27 June 2024, addressed to the Special Secretary Hall, put up a proposal for the detention of the detainee under Section 3(1) of the peak NDPS Act 1989. Thereafter, basing on the proposal of the DG, the Special Secretary Home passed the impugned detention order dated 4/7/2024. And along with the detention order, the special secretary also informed the detainee that he has a right to submit representation to various authorities. Thereafter, the detainee submitted his representation to the various authorities. And the representation of the detainee dated 05/08/2024 was rejected by the detaining authority. This is the special.
Who is the order, initial order? Detention order?
Yes, at page 17.
You're still under detention,
Yes, ma'am.
in judicial custody?
Yes, ma'am. Still under detention. After the detainee submitted representation on 05/08/2024.
What are the grounds? What are the grounds?
The grounds for revocation of detention.
No, what are the grounds?
The grounds are that being satisfied that.
Where?
My lord, the page 17, my lord.
16.
Page 17.
Itu to
Paragraph
delay. দিয়াৰ পিছত
Oh.
detention order লগে দিব নালাগে নেকি? এইটোতো হেৰি কৰিলো additional director দিয়াৰ পিছত secretary special secretary has passed the order and he has to give and second the grounds of detention. Detention order is not enough. The grounds of detention? Are you served with a ground of detention?
Yes, my lord. But the detention order.
No. Subsection 3 of section 3 of the PIT NDPS
Yes,
Act.
I have been served.
Where?
Also,
Where?
I have not enforced it. I've not given the detention order. And the grounds is mentioned here. That
Where?
para four, my lord, para four of the detention order.
Huh?
Para four of the
That is
detention
not,
order.
that does not comply.
On being satisfied that with a view.
That does not comply, Mr. Counsel. Page 17.
Let's see the records.
Para four. Yes, written para four.
Read subsection 3 of section 3.
For the purpose of five of Article 22 of the Constitution, the communication to a person detained in pursuance of the detention order of the grounds on which the orders have been made shall be made as soon as may be after the detention, or ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing, not later than 15 days from the date of detention.
True. Was it served?
Yes, sir.
Where?
Was served to me.
Which one? Where?
No, it includes the detention order, and in the detention order is reflected.
The council, subsection 1, this fulfills subsection 1 of section 3. This is a detention order. See subsection 1. This fulfills subsection 1. Then fulfillment of subsection 3 is required. Then- Hmm? Did you prepare any bail application? No. Have you stated so?
No, no.
Huh?
No,
In- huh? Have you stated so?
yes, my lord, in my grounds,
Tell me.
at page eight of my petition, I have not stated directly that I not applied for bail, but
Hmm?
ground number D, my lord. That I've been booked under section 18B
Hmm.
and the stringent provision of section 37.
37, yes.
I fall within that strict provision, so there is no chance of me being released. And the detention order was passed mechanically.
Forwarding of representation. Okay. This is the only case where you are. This is the only case,
Yes, ma'am.
no other case.
This is the only case I'm aware of. ma'am.
Yes. Grounds of detention.
I feel page 15 of the next.
Yes. This is the only case he was found involved with.
But he was in the business for the last 4 or 5 years, as per investigation, and he's already traffic about 85 kilograms of shit.
So 31.
So far, during the past 4 or 5 years, he has transacted traffic about 85 kilograms of PM per ship. And the six is 31 kilogram, 205 grams in the instant case. And now he has contact supplier in Manipur. Going by the name of Manhoki. In between 2000.
Hmm.
2022, 2024 alone, they have made 332 telephone conversations logic. So this intention is to break, to disrupt the network of illicit of trafficking, which in this case he was arrested along with one of his co-accused logic. Now, is in judicial custody, but unless he is, as the detention says, as per the material placed before the detaining authority lodging, unless the detainee was placed under detention or prevented from carrying out his trafficking lodging, if he's to be released, is likely to indulge in similar prejudicial activities, right? And now, one thing is not from the state.
Otherwise, there is a strict condition for bail under 37. And if the public prosecutor shows reason, it can be extended up to 1 year. And the maximum period in PIT NDPS is also 1 year.
So,
And where is the apprehension then? Under the proviso to subsection 4 of section 36A, it is up to 1 year till the investigation is completed. May extend the said period up to 1 year on the report of the public prosecutor. So under this act also, the maximum period of detention is 1 year. So how do you justify this ground?
because one ground argument I make in my statement is that if a person can be trial in another cases, that does not debar the authorities from passing preventive detention law. That is one argument I make.
Mr. Angami, you are referring to the 75 judgment. But 75, after the
Yes.
75 judgment, there are many other judgments which have come. Rekha is there, and then the other Manipur matter is there. But the Supreme Court have taken note of that 75 judgment and said that for the purpose of formation of the opinion, you have to arrive at there has to be a subjective opinion to the effect that he is likely to be granted bail. There's nothing, not a single word out there. And they were still, in both the advisory board and everywhere, they have referred to the 75 judgment.
Yes. Even the finding of the advisory board has already produced, but it said that there's sufficient cause to retain the law.
Advisory board of 8%. Advisory board of 8%.
Last time, during this time, I was sitting with this Michael.
Yes, my lord.
There are 2-3 judgments we have delivered on this aspect. You have a copies of them?
I have copies of that Manipur.
Manipur is there,
Yes,
but
I
we
do
have
know.
duly dealt with everything. Manipur, Rekha and all these things we have duly dealt with. Exactly during this period, we delivered these judgments last December. Yes, WP Criminal 9/2023. Date of the judgment is 12/2023. That is a judgment of 7th of December. 12 of 2020. You were the counsel who appeared in that matter.
Yes, my lord.
Then
Was the counsel.
Next one is same.
There are
Yes,
Poikus.
Wait,
Nasib Singh.
Nasib
Nasib.
Singh, Poikus.
the only difference is he was implicated in another case, not necessarily not in the PS, but that's the only difference. That is from the report logic. The one is he's a driver, and in same case he's the main dealer.
Grounds of detention are the same. There is a minor difference in the days of detention.
There is another file.
Item number 4, council is different. Mr. SOP.
My name is also there.
Okay. Heart. Be a separate order. Heard Mr. SOP. Learned counsel for the petitioner. Mr. K. Angami, KV Angami, learned public prosecutor for the state, and Mr. Anguli, learned central, Z Anguli, learned public, central government council for the Union of India, respondent Union of India. Arguments are heard. Order is, judgment is reserved. Same in item number 4.
C1. Nancy.
Sorry, itu bilang dan itu. Kok jangan bicara itu? What's the name?
Tapi ini mau di dia lagi jam.
Itu print out tuh tadi tadi. Itu print out kurang lah. It doesn't. Does it?
Yes,
Also, I beg to mention item number 15.
item number 15.
15. Here, Lordship, here, there's a bulky documents and lectures.
Hmm.
So I have, because of difficulty, I've sent back to the.
Item number 15. It has come for orders. Why?
Yes, order.
Orders for why?
We are yet to file a affidavit. It is covered in the order.
For any other reason? I don't.
Initially, your lordship, there was a
Okay.
difficulty in the respondent number 10. But now he has already responded.
Okay.
So the matter will be listed after
Oh.
application.
MS Learned Counsel for the petitioners is present, Mr. Imki Chong, Learned Additional Advocate General, Nagaland. Appearing for the respondent number 3 to 10 as spread for further 3 weeks time, 3 weeks time to file counter affidavit on behalf of the state respondents. Full stop. Whatever is allowed, list the case after 3 weeks. Mr. Jamir, you are there. Mr. Jamir. Learned Counsel for the respondent number 2 is present.
Your Lordship, I beg to mention item number 16.
Yes,
I need to
16.
file my affidavit, so kindly grant me 3 weeks time, Your Lordship.
Mr. J. Dan Gully, Learned Counsel for the petitioner is present. Miss I. Me, Learned State Counsel. For the respondent number
1, 2, and 3, Your Lordship.
1, 2, and 3 as straight for and is granted 3 weeks. How much time?
3 weeks. Your Lordship.
3 weeks time to file counter affidavit on behalf of the state respondents. Full stop. In view of the office note dated 18/9/2024, await for the service report in respect of the respondent number 4. Release the case after 3 weeks.
Your Lordship, I beg to mention item number 1 and 2 on behalf of my colleague Lee Jimo, Your Lordship. Kindly let the matter come up after the vacation. This affidavit is under preparation, Your Lordship.
Mr. Learned Counsel for the petitioners is present. Ms. A.I.M.E. Learned State Counsel representing Mr. V. Jimomi, Learned State Counsel for the state respondents have submitted that the counter affidavit on behalf of the state respondents is under preparation and same will be filed within 3 weeks time.
Yes, Your Lordship.
She has thus paid for listing of the cases after 3 weeks in order to file counter affidavit.
Your Lordship,
Also, the prayer
similarly,
is allowed, list the cases after 3 weeks from date to be fixed by the office.
similar prayer for item number 3 also, Your Lordship.
You are the counsel.
No, Your Lordship, on behalf of V. Jimo.
Affidavit is under preparation.
Yes, your lordship.
Same order. Miss
Yes, your lord.
A. Jeliang is present. I am London State Council representing Mr. V. Jimo.
Yes, your lordship. Your lordship, item number 4, on behalf of additional AG LT Santam, your lordship, kindly let the matter come up after the vacation.
Mr. You are the petitioner? Okay. MS Learned Council for the petitioner and Mr. Moaz Jamir Learned Council representing the respondent. NHIDCL authorities are present. Post of Ms. AIME Learned State Council appearing for Mr. LT Sanctum Learned Additional Advocate General Nagaland has submitted that the counter affidavit on behalf of the state respondents is going to be filed within 3 weeks' time.
Your lordship, after the vacation,
Ah.
he's yet to file affidavit, your lordship.
Okay. 4 weeks' time. The prayer is allowed. She has just paid for listing of the case after 4 weeks. The prayer is allowed, list the case after 4 weeks. On a
Lordship,
date to be fixed by the House.
Lordship, here, the respondent number 2 is also yet to file Union of India.
Mot. Who is there for Mot?
ZN
Yes, Z. Guli. Item number 4. You have filed your affidavit, Mr. Jamir? The respondent number 2, Union of India. They filed its counter affidavit on or before the next date of listing.
Item number 3, for hearing.
Yes.
Matter may be taken up the way.
Mr. Muazami, Learned Council Court of Petitions, has submitted that he has some personal difficulty today, and case be listed after the ensuing winter vacation post of MS. Lucino, Learned Council Court respond number 6, before that, Mr. N. Angami, Learned State Council for the state respondents are present and have no objection to the prayer made on behalf by the Learned Council for the petition. This is the case accordingly after the ensuing winter vacation.
Lordship, I beg to mention item 17. Lordship, I'm here to file my affidavit. Therefore, kindly grant me 3 weeks to file my
1770.
affidavit.
Let us see. MS Asenla Longkumar, Learned Council for the petition is in attendance. Miss
Provision.
Learned State Council,
And for respondent 5, private respondent.
respondent number 5. And who is for the state? They have not filed counter with you. Miss Miss
On behalf of Lordship, it is not reaching Gibson. And grant do some part.
Miss
It is not HG Gibson.
your name please.
Pichano.
Pichano, Learned State Council representing Mr. Imchand, Learned Additional Advocate General Nagaland. For the respondent number 1, 2, 3, and 4. And MS Learned Council for the respondent number 5 have both prayed for 3 weeks time. Have prayed for and are granted 3 weeks time to file their respective counter affidavits. List the case after 3 weeks.
I beg to mention item number 8 and 9.
8 and 9.
Lordship, on behalf of everyone. He's here to file affidavit, so it is better we come up after the vacation.
MS,
Rubika.
Learned Counsel for the Petitioners is present. MS Pichano, Learned State Counsel. Appearing for Mr. N. Longkumar,
Lordship.
Learned State Counsel. Have prayed for 4 weeks' time to file counter affidavits on behalf of the state respondents in the cases. First of the prayer is allowed. List the case after so and so weeks, so indeed to respect this. Yes,
Lordship, similar prayer with item number 10, on
10.
behalf of S. Mary.
Miss
And so,
Anne Solo. Learned Counsel for the Petitioner is present. Same Agoda is there, representing S. Mary Pichano. 3 weeks.
From the supplementary cost list for motion, item number 21.
Yes, Lordship.
Yes.
Your Lordship, I have filed this application for regularization passing on the MO 2015. Your Lordship, according to my service book, I was appointed in the year 1990 and served till 2023. After completing 33 years of service. And there I have written a representation to the department. However, my case has not been considered.
Okay, well, you should notice at this stage. Or Mr.
Column.
Learned Counsel for the Petitioner and Mr. N. Angami, Learned State Counsel for all the respondents.
Yes.
Yes, sir. It is the case of the petitioner that he was appointed as a work chairs Khalasi, and he was appointed as a work chairs Khalasi with effect from 21/7/1990, and he was released from service on 30/10/2023 on attaining the age of 60 years. Post-op. At the time of his release from service, the petitioner was enjoying scale of pay. Post-op. It is the further case of the petitioner that as the petitioner has rendered service for more than 30 years, he is entitled to be regularized as per the office memorandum dated 17/3/2015. Post-op. The petitioner stated to have submitted a representation on 28/3/2024, seeking his regularization in view of his continuous service of about 33 years. Post-op. When the said representation is not given consideration till date, the petition has approached this court by this instant petition, seeking an direction to the state respondents to regularize his period of service. Post-op. issue notice returnable in 4 weeks as Mr. Angami has appeared and accepted notice on behalf of all the respondents, issuance of formal notice to the respondents, said respondents stands dispensed with. However, extra copy within 3 working days. Thank you, Rashi.
I have missed a clear error in response number, instead of response number 5, I put number 4. So I may be allowed to make the correction. In synopsis, page 2.
Synopsis,
Yes,
only in synopsis.
and other pages, sir.
There is no requirement in the synopsis.
Yes.
If the main body is okay.
Right.
For admission, item number 5.
May please, my lord. Lordship, last time on. My lord, we kindly come to last time's order. Order. That is 29/8/2024. This honorable court directed the deputy commissioners in Lemboto for verification as to who is the land donated, where subdivisional office PWD RND RPC is situated.
Let me read it. Yes, affidavit.
Lordship, accordingly, yes, I have received my instructions. So if I maybe I want to place this on record.
I think this should be brought on light by affidavit.
Lordship. In the meantime, I also would like to make a reply to the.
Let them file your affidavit. Prima facie, your claim has been negated. So let it be on record so that you can contradict,
Lordship.
right?
Lordship.
Because Kotoi Sumi has himself admitted that he did not. I don't know. It is later, let it be on record.
Lordship.
Why should we reach a conclusion? Let it be on affidavit. Part
Or,
MS.
Lordship, there are two aspects here. Where in the first one, they have also placed before the Honorable Court the map, where page in the third page, the middle portion is the one the petitioner is claiming. The middle
No,
portion.
madam, there is a letter from P. Kotoi Sumi.
I was meant to say, just because I said that this is sub-divisional officer. So this sub-divisional office comes under the executive engineer PWD R&D Atoisen. That is a common name, Lordship. Then comes sub-divisional officer. So even in my petition, all my
No, madam,
certificates.
there is a statement, letter written by Kotoi Sumi, that I'd like to state that I made a false claim. Let it be on affidavit,
Lord.
then you contradict.
Lordship.
It will be better for you after getting this affidavit,
Lordship.
because there was a meeting. Let them come up. Hart, MS, Jed Zimomi, learned counsel for the petitioner, and MS Pichano, learned state counsel. For the respondent number 1 to 4. Poster. It is submitted by MS Pichano that an inquiry has been conducted by the Deputy Commissioner. Deputy Commissioner?
Lordship.
Deputy Commissioner Juneboto, in deference to the order dated 29/8/2024,
Lordship,
and
this
thereafter
extra
a
assistant
report.
commissioner, not deputy commissioner exactly, ADC.
No, in the order, in the 29/8/2024 order, court is of the view that Deputy Commissioner Juneboto shall cause an inquiry.
Yes,
That is
yes,
the order.
yes. But the office, his office has conducted it
Ah.
under him, subordinate officers.
He is taking the responsibility.
Lordship.
It is signed by Deputy Commissioner.
No, no.
The office of the Deputy Commissioner has conducted an inquiry in deference to the order dated 29/8/2024, and thereafter has prepared a report. Post-op. MS Pichano has submitted that C may be granted. What time to file, to bring on record?
3 weeks, Lordship.
3 weeks. She may be granted 3 weeks time to bring the said inquiry report conducted by the Office of the Deputy Commissioner Juneboto on record by way of an additional affidavit. The prayer is allowed, lays the case on. Give it after 27/1.
Oh, Lordship.
For admission, item number 6.
No, 11/3/24. State council has.
Yes,
So time to file affidavit.
yes, Inaholi. Yes,
I'm for respondent for private respondent.
private respondent.
Yes, I already filed my affidavit.
State respondent. Yes, MS Pichano. On the previous occasion, MS Inaholi sought time to file counter affidavit.
Fairly got 3 weeks time to file.
Okay. This is regularization or what?
Lord,
Heard Mr. Muajamir, learned counsel for the petitioner. MS Pichano, learned state counsel representing Ms. Inaholi. Learned state counsel for the respondent number 1, 2, 3. And MS learned counsel for the respondent number 4. You are filing any affidavit? Huh?
she has
Already filed. MS Pichano on behalf of MS Inaholi has prayed for and is granted further 3 weeks time to file the counter affidavit on behalf of the state respondents. List the case after 3 weeks.
For admission, item number 7.
So I may be allowed a week's time to file affidavit in client.
Mr. Muajamil and counsel for the petitioner has prayed for and is granted 1 week's time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. List the case after a week. I think it will be immediately after the ensuing some winter vacation.
For admission, item numbers 11 to 13.
Yes, Your Worship.
Yes,
Your Worship, I'm praying that item number 12 will be taken first, Your Worship.
12.
Yes, Your Worship. Your Worship, on 14/11, this honorable court was pleased to appoint Justice Hukato Suo, but he had refused to be the sole arbitrator. As such, Your Worship, I'm placing the notification whereby the panel of arbitrators are there. So I'm praying that the arbitrators will be appointed.
1 minute. 1 minute. Yes.
Your Worship, I'm praying that any arbitrator will be appointed from this list, Your Worship.
Yes, Mr. Seki.
Hello, if this is the list that has been prepared by this honorable court, My lord, any of the judges, if they are agreeable, we're not averse to any of them being the arbitrator, my lord.
Or if you have a consensus of one other than this,
My lord, I will leave it to your lordship to appoint any of the arbitrators.
Mr. Su was in list of in the panel.
No, your lordship, his name was suggested by this honorable court.
You can think of Justice Prakhanda Kumar Deka.
My lord. Lordship.
Heard Mr. Joshua Seki, learned counsel for the petitioner, and MS Priana Setri,
Yes.
learned counsel for all the respondents. Full stop. This application is preferred under section 11 of the Arbitration and Conciliation Act of 1996. Full stop. For appointment of an arbitrator in respect of a dispute which has arisen between the parties herein. Full stop. When the application arbitration petition was listed previously on 14/11/2024, this court deemed it appropriate to appoint Mr. Justice Fukato So, former judge of the Gauhati High Court, under section 11 within bracket 6 of the Arbitration and Conciliation Act, to act as a sole arbitrator to resolve the disputes between the petitioner and the respondents, subject to the disclosure of the learned prospective arbitrator as required under section 12 of the Arbitration and Conciliation Act. Full stop. The parties were permitted to place a copy of the said order before Mr. Justice Fukato So, former judge, Gauhati High Court, in order to confirm his appointment. Full stop. Today, the learned counsel for the parties have submitted that Mr. Fukato So, former judge, Gauhati High Court, has expressed his disinclination to act as the arbitrator for resolving the dispute between the parties herein. Full stop. In view of such development, and taking into the view the observations made in the previous order dated 14/11/2024, this court considers it appropriate to appoint Mr. Justice Prakhanda Kumar Deka, former judge from Gauhati High Court, to act as the sole arbitrator to resolve the dispute between the petitioner and the respondents. Full stop. This appointment, is, however, subject to the disclosure of the learned prospective arbitrator as required under section 12 of the Arbitration and Conciliation Act. Full stop. Previous order to 11 to 11 to Maridigo. Instead of Justice Hukatusu Rohanto Kumar Deka. And let the matter be listed again after the vacation.
Yes, Your Lordship, fixed date will be given.
So this is 27 January. Monday. Yes, Mr. Seki, 27 January 2025.
Your Lordship.
27 January 2025. A date to change for you. List the matter again. That's a 12 to date to change for you. Just now to change for you. Who cattle so tight for Hunter Kumar. Our date to 27/1/2025.
Lordship. Now, my lord, in item number 11,
Yes.
Your Lordship, instead of going into the details of the argument, we're aggrieved by the letter dated 11/9/2023 that has debarred my company, my client's company for more than a year now, Your Lordship. So, my lord, when there is an arbitration clause, as far as the law is concerned, my lord is aware that the law is settled that
No, debarred, who debarred?
the respondents, the Airport Authority of India has debarred my company, Your Lordship.
That
So
is, it is blacklisting kind of.
Yes, blacklisting, my lord.
Ah,
So, my lord, when there is an arbitration clause and we are ready for arbitration, this debarment, it directly affects the livelihood.
no,
of the person.
debarment is separate issue.
But, Your Lordship, when there is, when arbitration clause is there, Your Lordship, I may be allowed to place some authorities before Your Lordship.
Yes, you are ready?
Yes, Your Lordship.
Twenty 2024 SCC online, Supreme Court, 1896, Your Lordship. I'm relying on paragraph 14, 22, 26, and
No,
26.
show me that because of arbitration clause,
Yes, Your Lord.
blacklisting is not permitted.
Yes, Your Lordship.
Which one?
May I first take Your Lordship to paragraph 14. I'll give you a list.
Yes.
What I'm trying to find out exactly the sentence that my lord has asked for. Your Lordship, I may take your Lordship to 2011 SCC. Next,
Uh-huh.
2011 SCC online.
Good. I'm taking 2024 as
Yes, your Lordship. So I may be allowed to
Huh?
rely on 2011 SCC online, your Lordship. 93. May I take your Lordship to close 23.
No, decision.
Your Lordship.
That when arbitration parties have invoked the arbitration clause, blacklisting is not permissible
Yes, your Lordship.
because you have opened your submission with that.
Yes, your Lordship. I may take your Lordship to the next page. After
In
close 23.
2011.
Yes, your Lordship.
Yes, clause 23.
After that, your Lordship may come to the next page and again the next page, your Lordship. May I take your Lordship to the blacklisting in block letters, as my Lord said, blacklisting.
Ah.
Then next to that paragraph, your Lordship, in all these cases, in my lordship, the subpara after the blacklisting in block letters, your lordship, below that, in all these cases, the apex court was of the view that blacklisting in respect of business venture has civil consequences for a future business of the person, natural justice that parties affected by any order should have right of being heard in particulars is not a proper show cause notice without material justice, and one cannot be expected show cause notice as required by the principles of natural justice, where a corporation is an instrumentality or agency of the government in exercise of its actions.
Getting in all these cases,
Yes, your lordship.
you are reading that paragraph.
Yes, my lord, my lord.
Okay.
It is true, as suggested by the Advocate General, that the scope of judicial review in matters of contract and tenders is
You're
limited.
not far. Yes. The apex court was of the view that blacklisting has.
Yes, I'm reading that paragraph, your lordship.
So, yes, when you read full.
Yeah, I started from the beginning. your
Okay,
lordship.
start
Oh,
again.
stop. In all these cases, the apex court was of the view that blacklisting in respect of business venture has civil consequences for the future business of the person concerned. And even if the rules do not expressly provide an elementary principle of natural justice that parties affected by any order should have right of being heard and making representations is a cardinal rule. A show cause notice issued without material particulars is not a proper show cause notice as required by principles of natural justice, and one cannot be expected. The
No,
notice
obviously,
to give an effective. Your lordship. Obviously.
Yes.
Yes.
One cannot be expected, yes.
Yes, your lordship.
Ah,
Obviously, where a corporation is an instrumentality or agency of government in exercise of its power or discretion, it is evidently subjected to the constitutional limitations, and arbitrary action is liable to be questioned by the court of law. It is true, as suggested by the Advocate General, that the scope of judicial review in matters of contract and tenders is limited. But in the case of Ramana Dayaram Shetty versus International Airport Authority of India, 1979, 3 SC 489, it was held that cases involving blacklisting stand on a different footing as they require high degree of fairness in action. The Honorable Supreme Court in Siemens Public Communications Networks Private Limited versus Union of India, 2008, 16 SCC 215, held that cases involving blacklisting or imposition of penal consequences of a tender, a contractor, or distribution of state largesse stands on a different footing. Thus, in my view, the order of blacklisting during continuation of arbitral proceeding cannot stand the test of natural justice, and it is liable to be set at naught for a reason that a factual dispute, which is contractual in nature, raised in the show cause notice, was already subject matter before the sole arbitrator duly appointed by the High
Mr.
Court.
Seki, this is a decision where the show cause notice was subsequent to arbitrate proceeding. Show me a decision
Well,
that show cause notice preceded arbitration proceeding.
well,
Then show cause notice is to a blacklisting, or show cause notice is to be set at naught. This is not the, because I think I have not opened the brief, but from your submission, it appears that the blacklisting is already in force
yes, Your Lordship.
and arbitration proceeding is yet to start.
In fact, Your Lordship,
Is it not?
yes, Your Lordship. There's another point also which can be considered by this honorable court.
Show me this,
No,
whether
no.
this is not the, because
Yes.
arbitrator is now is in seizing of the disputes.
Your
And
Lordship.
he is in the process of resolving a dispute. In that context, this has been made. At least I am aware of all this Kulja and all,
Your
to
Lordship.
an extent, erosion.
No, my lord, number one, if my lord may kindly
That-
consider this other point. My lord, the blacklisting was done after the contract period was successfully concluded. Now, my lord, blacklisting, if you go by the.
No,
commercial-
tell me the blacklisting is permissible, but whether it was preceded by the proper opportunity of being heard, proper notice,
Your Lordship, the
that
entire, yes,
notice, opportunity of submitting an effective representation.
an
and,
opportunity was, yes, Your Lordship.
Ah,
To that extent, Your Lordship, I agree. But Your Lordship,
In a
to the
notice,
extent.
the grounds,
Yes, Your Lordship. notice was given to us.
Grounds were indicated.
Grounds were indicated, Your Lordship. Yes, I agree, Your Lordship. Now, what happened, Your Lordship? We asked for who is the person who complained against us. That was kept completely in the dark, Your Lordship.
No. Complaint against us is different thing. But notice has been sent to you
My Lord.
and some deficiencies are indicated or what?
Yes, Your Lordship.
Some deficiencies are indicated. You have
Deficiency in a sense, Your Lordship.
alleged deficiency.
Yes.
You were not supposed to know who is the complainant, whatever. What is the requirement?
No, my Lord. The deficiency so projected, Your Lordship, is not actually a deficiency, my Lord, because after the completion of the contract, Your Lordship, they certified that our service was satisfactory. Contract period was closed. The earnest money that was deposited was also given to us. After everything was done, Your Lordship, after a period of more than a year, Your Lordship,
Okay.
somebody somewhere lodged a complaint against us, and an unknown person lodged a complaint
Where is
against
the
us.
so-called notice? Where is the so-called notice?
Lordship, the first purpose notice,
Show me the contract first.
my Lord.
There is a-
Page 23, Your Lordship, page 23, starting from page 23.
No, so 23 is. I don't know which you are arguing which case?
Item number 11, my Lord.
No, 11 is what? Read
Your Lordship, this is read petition number 232,
read petition.
232 of 2024, my Lord. This is the contract agreement.
Hey, this letter is to be before the arbitration petition. Inside that arbitration. Okay. License agreement for cafeteria
Yes, Your Lordship, the vehicle parking area.
and vehicle parking area at Dimapur Airport.
My Lord.
Okay. 2 year,
Yes, my Lord.
valid for a period of 2 years. Okay. Where is the arbitration clause otherwise? Just me.
Your Lordship, the arbitration clause is at page 37.
37. Okay. Now the notice.
No, Lord, before going into the notice, if my Lord may kindly permit me to show Your Lordship the page 47 and actual 4, Your Lordship, page 47. This is the certificate, performance certificate issued to us after the contract period was over, Your Lordship. Here it, my Lord.
Yes.
To whom it may concern. Dated 19/10/2020, my Lord. Performance certificate. This is to certify that MS Sana Enterprises, proprietorship firm of Ms. Sanchana Gupta, having its registered office near Eros Cinema, Dimapur, Nagaland, 797112, was awarded a contract for operating cafeteria stall at vehicle parking area at Dimapur Airport for a period of 2 years from 24/05/2018 to 23/05/2020. The said period was further extended for a period of 3 months, that is from 24/5/2020 to 23/8/2020. The said firm has successfully completed 2 years and 3 months of the contract, and the performance of the firm is found to be satisfactory.
Show me he is a competent authority.
Your
Who
Lordship,
is the competent authority to certify otherwise as per the agreement?
the agreement.
As per the agreement, who represents the airport authority?
Your Lordship, include its chairman or member executives, airport officers.
Know who certifies, basically. Who represents the airport authority?
That is why, your lordship, in the agreement, may take your lordship the page 23.
Huh?
The airport director.
Director.
Your lordship will go by the
Yes.
agreement, not by the submission of my learned friend, my lord. Kindly come
yes.
to page 23, my lord. Page 23, annexure 2. May I read, my lord?
Hmm.
This agreement made this day of 24/05/2018 between the Airports Authority of India, a body corporate constituted by the central government under the Airports Authority Act of 1994, and having its corporate office office at and offices at all airports in India, represented by hereinafter called the authority, which term shall, unless excluded by or is repugnant to the context, be deemed to include chairman or member, executives, airport officers, or any of them specified by the and chairman in this behalf, and shall also include its successors and assigns. So, your lordship, it's not just the director, my lord. There are several authorities. So, my lord, even the performance certificate has been signed for airport director. When we come to page 47, my lord, was certified by the appropriate authority, my lord. Now, my lord,
Hmm. Yes.
before we go into the show cause notice, may I take the lordship to page 92? It's a very short document, only the relevant portion, the lordship. Page 92, annexure 25, my lord.
Yes. $92.
The relevant portion, your lordship, at page 95. 92, this is the commercial manual 2019, which is followed by the airport authorities, also, your lordship. This is how the business procedure is to be conducted, my lord, especially when it comes to the process of debarring, your lordship. Page 95. Starting from 8.12.1.
Yes.
Here, read, my lord. In case of breach of terms of concession, license, that is non-compliance to terms and conditions of the agreement, NIT, and or non-adherence to the laws of the land, minimum 7 days preliminary notices to be issued to the concessionaire, licensee, seeking clarification and rectifying the non-compliance. However, in case of no fulfillment of preliminary notice by the concessionaire, licensee, a show cause notice to be issued, the reply to which has to be submitted by the concessionaire within 10 working days from the issue of show cause notice. If warranted, the concession license may be terminated by the competent authority on recommendation of the LCAC or CAC, and necessary action may be taken to debar the agency for future participation. Next, my lord, 1812.2. The following circumstances, conditions shall form the basis for debarment of an agency. Roman 1. In case of the opening of the technical bid and before opening of the financial bid, if any agency withdraws from tender process, the EMD, earnest money deposit of the party, shall be forfeited, and the party shall be debarred for participation in any tender at the said airport for 1 year from the date of debarment. 2. However, after opening of financial bid being H1 in the tender, if the party withdraws its bid or after issuance of award letter, the party does not complete the requisite formalities within the prescribed period, EMD shall be forfeited, and the said bidder will be debarred from participating in any tender of AI for 1 year. 3. If the licensee concessionaire terminate the license without serving the requisite notice of 30, 60, 90, 120 days, depending upon the license period, its security deposit is liable to be forfeited, adjusted as per para 20 of chapter 7.13. 4. If any concession/license is terminated due to fraud, providing wrong information or misrepresentation of the facts in the tender. In case if any license is terminated due to illegal activity which is punishable under any of the laws of the land, then a party will be debarred till the case is cleared by the concerned legal authority of the land. My lord. 6. In case the license is terminated due to outstanding dues being uncleared, unpaid by the licensee even after adjustment of security deposit against dues, and at least 3 notices for recovery of dues have been served upon the licensee. Then, my lord, 18.12.3. The debarring of an agency shall be for a period of 1 year, 1, 2, 3, and in case of 4 and 6, the debarment shall be for a period of 3 years. Steps to be taken for debarment of an agency, my lord, 18.12.4. In the first instance, a show cause notice shall be issued by the concerned airport director for a violation of breach of concession/license in respect of circumstances, conditions as mentioned above, as the case may be. A time frame that is 10 days from the issue of show cause notice should be indicated for replying to the show cause notice. On receipt of reply or after time period to reply is over, as the case may be, tender processing officer of the station concerned will process the case with all facts and supporting documents and place the same before LCAC or CAC for consideration/deliberation. An opportunity should be given to the person adhering to the delinquent of agency to place his submission by the accepting authority. The LCAC or CAC will examine and verify the facts and recommend the course of action for approval of the accepting authority. The competent authority, as per DOP, shall give the decision on the recommendation of LCAC or CAC, CAB, as the case may be for debarment. Once the approval is received by the Department of Commercial, a communication shall be sent to the delinquent agency for debarment outlining the breaches, mentioning the period of debarment and description of concession/licenses, etc. PAN of the agency should also be mentioned in the debarment order. General notice is to be issued and circulated to all airports, regional offices, and also pasted on the notice boards, uploaded on AAI website for wide publicity. Here, Your Lordship, it's in their website. The agency will be eliminated about the debarment of airport, will be intimated about the debarring by airport RHQ, CHQ, as the case may be. The complete process shall be done within a maximum period of 60 days from the show cause notice. The debarment agency may make an appeal to the next higher authority against the debarment, who after deliberation will give his decision. So, Your Lordship, here, the reading of this clearly shows that, my Lord, for debarment, the debarment process, it has to be issued when the contract period is still alive, Your Lordship, where at the end of the day, before the procedure is complete, the EMD will be blocked. The contractor licensee cannot withdraw the EMT, Your Lordship. So, Lord, here is the case where the whole process was complete. My Lord, on this basis, if I may be allowed to show one decision to Your Lordship.
No, you have not taken me to a show cause notice. Let me have a look at least.
My Lord, I will come there, but what I'm trying to say is the contract period was over.
Decision will be later
Lordship, Your Lordship.
because you have started with your decision. I found out to be not applicable.
I wanted to make it short, Your Lordship, especially on a specific point.
But that point was not there. The judgment you have shown
So I'm trying to show Your Lordship
that arbitration proceeding is on. So no debarment. That is not the law.
In fact, Lordship, if we go through the entire judgments, Your Lordship, I have many decisions, Your Lordship. So
The judgment you have shown, that is not applicable.
that I agree, Your Lordship. I agree with Your Lordship. Now, the judgment now I'm trying to show Your Lordship is contract period is over.
Once beaten, twice shy. So that is why I am not looking at your next decision.
I will satisfy Your Lordship, my lord.
You have the time to satisfy, but let us see that show cause notice. Where is that?
My lord, I will show Your Lordship. Page 55, Your Lordship. Does my lord come to page 55?
Hmm. So where is that performance certificate?
Your Lordship, page 45. Page 45, Your Lordship. No, my lord, page 47, 47.
No, no. The one mentioned in the show cause notice on which you got the contract.
Yes, Your Lordship. Lordship, page 75 to page 78, Your Lordship. So some of the documents.
Now, how do they verify it? How the airport authority had verified about this credential of this document?
Your Lordship, we have produced it. Though, Your Lordship, if we go by the tender, if we go by the tender notice, we're not even supposed to produce these things. These are just some of the additional information we provided to the airport.
No,
And
criteria.
yes, Your Lordship.
Now, what are the criteria on which you got?
My lord. My lord,
You are not supposed to give any eligibility criteria.
my lord,
Supporting document,
yes, Your Lordship.
what are the criteria in the tender notice, NIT.
May I take a lordship to page 19, annexure 1.
There is always an eligibility criteria.
Lordship.
Nobody can. Every person cannot submit a bid, right?
My lord,
There is a
your lordship,
set of eligibility criteria
your lordship.
under which one is permitted to take part in the tender process. It cannot be if Mr. Seki or myself
My lord,
go to the
your lordship.
airport authority and submit a tender, will not be. Because if you go through the Ramana Dairam City, that is also a restaurant in an airport. That is a starting point of law regarding judicial review in a contractual matter, right? Ramana Dairam City is also opening of a restaurant in an airport,
Lordship.
right? Class 1 or class 1B, whatever.
My lord,
This much of experience.
your
So
lordship.
when in 1969, experience was required, why not in 2018? Tell me, what is the eligibility criteria? Can you assist us? Eligibility criteria? Because everything is dependent on that.
Your lordship, may I take your lordship to page 67? Now, these are the general information or guidelines.
No, because here is a particular tender process.
This particular
You can,
tender document, your lordship, the airport authority will have to produce.
Because see, your document, whether it is the basis of your qualification or it is a supporting document, that is,
Madam.
it is not a necessary document to be gone into. That is the most important question.
My lord,
Because if on the basis of this document, you acquired the eligibility, or irrespective of this document, you have the eligibility.
yes, your
If
lordship.
the first is that it is the basis of your eligibility, then it is a very pertinent question.
Correct.
Because the question of fraud comes in.
Yes, your lordship. Now, I got your point, your lordship.
And if it is only an additional document, okay, to participate in the civil service examination, graduation is required. You have the graduation. Thereafter, you have doctorate, MBA, LLB, everything.
My lord,
That is not the issue. Whether your graduation document certificate is genuine and authentic or not. Have you understood my query?
definitely, your lordship.
So, they have pointed that you have submitted this document which is found out to be incorrect. If it is so, then if this document is the basis for your eligibility, then it goes to the root of the matter. But
Right.
apart from this, you have 10 other documents of such kind. Every other document is genuine. It is only an additional document you have given
My lord.
as an abandoned precaution. That is a different matter. But that is why I don't know.
True, your lordship. That's why my lord wants to see.
Blacklisting is a power which is available to the employer.
My lord. Your lordship.
If the very basis of getting the award is vitiated with something, then it goes to the root of the matter.
Can we list it on Thursday, my lord, so that I
It will be,
can.
Your Lordship. Your Lordship, the document which the petitioner submitted, by which the tender was issued to your Lordship, in my humble submission, it's a fraud document, Your Lordship.
That I have understood.
Your Lordship,
But
because-
whether,
because-
no, each and every fraud document, see, in every advertisement, say for job, essential qualification, say
My
graduation,
lord. Your lordship.
right? An MBA degree is desirable. LLB degree will be a preferential qualification like that. But basic criteria is say graduation. So here, he has submitted this document page
75 minutes.
75. From one
CSA
infra.
Your Lordship, but the
That
basis.
he
your-
has the experience of 3 years of operating
Yes, Your
a
Lordship,
cafeteria
in Himachal.
in Himachal. That is what?
He
This.
submitted, yes.
And what is the requirement in the tender notice?
But Your Lordship, the in my submission, the CSA Infratech Private Limited is a company established in the 2017, Your Lordship.
Okay,
So the back date is given to the petitioner.
okay.
Whichever
that is
way, my
the-
lord,
It is a private limited.
Yes, Your Lord.
can we list it on the Thursday, my lord? I will bring the tender document.
Your Lordship, if
Because the blacklisting is more than a year and it has greatly affected my client's company, my lord. It's a matter
No,
of life.
Blacklisting order is passed.
My lord.
So it is operating. For how many years?
1 year, 3 months,
No, total period is what?
3 years, Your Lordship.
3 years.
Yes.
Yes, your lordship, and it's been more than a year.
Your
It's
Lordship,
already 1 year, 3 months. So my lord, we may be allowed
Let
to.
me see.
Your Lordship, if I may advance my amendments.
1 minute, madam.
on the rest, yes.
Where is the show cause notice?
Page 55, my lord.
Your Lordship,
Yes, the document is on record in the other case, my lord.
Your Lordship, the one
Ah.
is fallen from the Lordship.
Oh.
It is, there's an item.
Well, I own it. But madam, why you not explain that why this is found out to be invalid document in the so-called?
Your Lordship, we have got a recommendation from the Vigilance Department that the petitioner submitted three documents and to be by.
Right.
Yes, Your Lordship.
Now, what are the criteria? What should be contained in the notice? What should be contained in the notice? You said merely invalid document.
Yes.
Whether that is sufficient opportunity, an adequate opportunity.
Yes, sir.
How? Invalid, you said invalid, is it not? Yes, that is the main criteria for his eligibility, experience criteria, it looks like. And that part is okay, he is the tenderer, he knows that this kind of document will cleanse his eligibility. But when you put him on show cause notice, you simply say that it is could not be established, then one is that you refer to the clause, that's okay. But why it is invalid? Do you have the Kulja? Kulja Industries.
Lord, I couldn't understand what my lord has said.
Kulja Industries decision.
Oh, my lord. Oh, my lord.
No, what are the exact form should be form of the show cause notice for blacklisting of contractor?
Your Lordship, in our show cause, we have show cause notice where written the performance certificate could not be
Yes. That is why I am asking you whether it fulfills the criteria laid down by long line of decisions of the Supreme Court. Because it is civil debt for him for 3 years. Maybe he has adopted something not bona fide, but you have a corresponding duty to put him on notice. And what should be the notice?
No, the action should have been initiated when the contract.
What should be the content of the notice? You should have argued down that point, Mr.
No, my lord, in the other petition, the tender document is,
No, I am saying now on the contents of the notice.
my lord, your lord.
Going here and there will not do.
Well,
It appears that it is the eligibility document for you. And you cannot deny also that that document you have furnished for purpose of establishing your eligibility.
yes, your lordship.
You don't have any other experience certificate, tell me.
In the eligibility.
Tell me the tender condition.
Your Lordship,
1 year, lordship.
Please read. Please read.
Your Lordship, it is in the item number 30.
Tell me.
May I read, my lord?
Tell me what should be the condition of it.
On behalf of the Chairman Airports Authority of India, notice inviting me tender in the.
No, tell me the condition
Yes, your lord.
of eligibility. Why should I read everything?
No, my lord, just read that part, your lordship. The
How much experience?
condition number 3, my lord. Parties
How much
fulfill the-
experience required?
1 year, 1 year.
1 year.
Yes.
And what? Where?
The parties fulfilling the following criteria are eligible to participate in the tender. A, parties having same type of business during the last 1 year eligible for participation, or B, food retail chain company running food courts, stalls in mall or airports or bus terminus, ferry terminus, etc. And with 1 year experience having multiple brand products can also participate, provided they have 10 such outlets in India. This is an or. the
So
option.
second part is gone. The first part. Please read the first one again.
The parties having same type of business during the last 1 year are eligible for participation.
1 year.
Madam.
Same time. Cafeteria.
Yes, your lord.
Cafeteria.
My lord.
So other than this document, do you have any other experience?
Lordship, this is all that my.
No. So that is the document which has created your condition of eligibility, which has fulfilled your condition of
Your
eligibility.
lordship. After the contract period was over, my lord, because.
That is, but
Your lord.
question is that fraud, wherever, at what point of time? It may be after that, or it may be before that, it may be in the midway. Right? But another question is that whether this document show cause notice fulfills the requirement of adequate opportunity.
And Your Lordship, another question would be, can the petitioner invoke two jurisdiction at the same point of time in the same court, Your Lordship? Item number 12, which was listed just now, Your Lordship, this honorable court referred the matter for arbitration. It is the same subject matter in this petition also.
Huh?
The subject matter of item number 12, just now, Your Lordship.
Arbitration petition.
Yes, Your Lordship, just now, Your Lordship.
And there is another one. What is
No, your
that?
lordship.
Huh?
This,
Your Lordship.
my learned friend has misunderstood the petitions, your lordship. The law points are different.
No, Your Lordship.
This one is
Your
again
Lordship,
the debarment, your lordship, the blacklisting. We want the debarment, the blacklisting to go because arbitration proceeding is about to begin, your lordship.
Yeah.
The arbitration petition is only for appointment of the arbitrator, my lord.
Your
It is
Lordship.
not to be
Your Lordship, the
misunderstood.
subject matter in item number 11 and 12, Your Lordship, is the same. Is the debarment letter of dated 11/9/2023, Your Lordship.
That seems
The
to have
arbitration
become
petition,
infractions, your lordship.
the arbitration petition was filed by the petitioner, Your Lordship. In
And
item,
what is this civil revision petition?
there is, Your Lordship, if I may say the gist of the matter, Your Lordship. Your Lordship, department letter was issued on 11/9/2023. Thereafter, they knowing that there is an arbitration clause in the agreement, they did not come for arbitration. They filed a civil suit before the learned trial court. The learned
For
trial
what?
for staying of the operation of the department letter.
That petition has become infructuous. Your Honor.
Your Lordship, if I may
Which one?
complete.
That petition has become infructuous because arbitration clause is there. And the district court
No.
below has no authority to appoint arbitrator.
Your
So
Lordship,
that is also expressed in the order itself, my lord, in item number 12, my lord.
Your
By the
Lordship,
learned court below.
Your Lordship, if I may be allowed to speak.
No, what is this? Tell me one by one, then one shall remain.
Your Lordship,
Item number 13 is what? Please tell me.
Your Lordship, it's a civil revision.
Please
it's a
tell
revision-
me very briefly and simply.
Your Lordship, in civil revision number 17, Your Lordship, the learned trial court had passed an order 5th April 2024 for staying of the operation of department letter 11/9/2023, which was in their favor, Your Lordship. They have enjoyed the stay for so many months. Thereafter, we file a
In a
separate-
civil court,
Yes, Your
they
Lordship.
prefer civil suit
Yes, Your Lordship.
and.
And they managed to get a stay.
Invoking what? Section 8 or what?
No, section 8 was filed by us, Your Lordship. After they got an ex parte stay, Your Lordship, on the department letter, we filed section 8 application saying there is an arbitration clause. Thereafter, full hearing was done. The court, after having knowing the section arbitration clause is there, referred the matter for arbitration. However, Your Lordship, the learned trial court erred in law by making the interim injunction final. Thereafter, we challenged the same before this honorable court by way of civil revision. And the order was stayed by this honorable court of the trial court. Thereafter, Your Lordship, the petitioner comes up and files this writ petition. It is an afterthought because we managed to get the stay by this honorable court, Your Lordship. And also this arbitration petition number 12, Your Lordship, is also filed by them on the same cause of action on the department letter. There is no dues pending, Your Lordship. So it is the same department letter which the petitioner has filed 3 jurisdiction, 1 in civil court, 2 arbitration petition before this court, and now the writ court, Your Lordship. As such, I'm in my humble, respectful submission, Your Lordship, this writ is not maintainable.
Respectfully, my lord, my learned friend has fully misunderstood the petitions pending before his own court, my lord.
Tell me your side of the story one by one shortly.
My lord. No, my lord, number one, we have not enjoyed, the petitioner's company has not enjoyed the interim relief for even 1 day because it was there since 11/9/2023 on their website. It is still there. My lord, as far as the item number 13, the civil revision petition is concerned, I fully agree. I have already conceded before this honorable court that the learned court below has no jurisdiction in the first place to grant the interim injunction to continue for perpetuity, Your Lordship, when it has no authority to appoint the arbitrator in the first place. So, my lord, on that case, I have
And what
fairly-
is this
yes, Your Lordship.
arbitrator appointment?
Arbitrator's appointment, Your Lordship, because we disagreed with their choice of arbitrators, my lord. There are 2 parties, so we cannot appoint the arbitrator which is of their choice, my lord.
To resolve what?
To resolve the dispute as far as these documents are concerned, my lord, though we are pointing out before this honorable court, it will be fairly decided by the
See,
arbitrator.
then if you are invoking on that particular document, which becomes a disputed one then
Lordship.
why this petition?
No, my lord, no,
So the 2 things,
your lordship. My lord, since arbitration is about to begin and the contract period was over,
no, you have
And,
received the money,
my lord,
you have received the money for
Yes,
operating
yes.
cafeteria.
yes, your
There is no dispute, otherwise persons have contractor and the employer has a dispute regarding money always. That is not there.
my lord,
The contract period is over,
yes,
then subsequently it is debarment order,
yes,
which has come.
my lord,
So what the arbitrator will decide,
no, my lord,
the document or what?
my
Tell
lord,
me,
yes, whether this document is genuine or not, whether we were genuine or not.
invocation of arbitration is previous to the writ petition?
Yes.
Invoking the clause, arbitration clause?
My lord, so this dispute will be decided by our arbitrator, but my lord,
Which dispute?
the dispute that we have submitted fraud documents and have misled the authorities that has led to.
Then
the
what
debarment.
will decide?
No, my lord, accept the debarment. In this writ petition, I want the debarment to go so that
whether we
No, if
are,
the
we are
document is
genuine or
found out to be false,
my lord.
turned out to be true, then the department order will automatically fall.
Your Lordship,
And
what-
secondly,
After the arbitration proceeding is over, if we are found to be false, your lordship, then definitely we will be bound by the department, your lordship. The extra penalty will be taken on us, but
No,
for now, your
no,
lordship.
if your
My
writ
lord.
petition is allowed,
My lord,
if your writ petition is allowed,
my lord.
what is, will be the result?
No, that the department will go for now, then we
Huh?
go for,
Then ho-
arbitration.
If the department, if the writ petition is to be allowed, the department order is to be set aside.
Yes, for now, your lordship.
Then, what is the purpose of the arbitration proceeding?
No, my lord,
Mr. Seki, what you are,
no, your lordship.
no,
They will
multi-pronged
decide on the
attack.
damages also, your lordship. Now we have been debarred for more than
No,
a year,
are you-
lordship. We have suffered loss of business. At the end of the day, if
Then
at
you
the
should have
moment-
waited for that.
the present debarment order, your lordship, if the present debarment order is set aside, it doesn't mean that they cannot debar us again, because the proceeding will
Oh,
go on.
injunction in perpetuity is not there. And once that order is set aside, then what?
what will the
will remain?
arbitration-
What the arbitration?
No, your lordship.
I'm not understanding your concept of
Yes, your lordship.
litigation. I'm not understanding your concept of litigation. But first civil, then invoke arbitration clause. Now this is petition.
Yes.
And contract has been worked out. The contract agreement has been worked out already between the parties. You enjoyed for 2 years. You operated the cafeteria for 2 years. You got all the money. The only question remains is the debarment order. And related to this, it starts with show cause notice,
Madam.
then reply,
Your
then
lordship.
the order of debarment. These
Yes,
three.
your lordship. Yes,
And
your
all these three is based on a particular document,
Madam,
right?
your lordship.
On the basis of which you got the contract. These four are the things,
My lord,
right?
your lordship.
So, what, for what purpose you are?
No,
in-
the
no,
debarment has not been issued after the, this is a debarment which.
This is a
issued-
fraud. If it is to be proved, it is a fraud.
If it is, yes, your lordship, then we can be debarred, but for now, since there is an arbitration clause.
No. This is not the idea.
My lord.
This is not
Then,
the
my
idea
lord,
of blacklisting.
May I beg your lordship, if this matter can be taken up on Thursday, I will bring the judgment to your lordship's satisfaction.
What,
My lord,
you have already brought so many judgments, so many books
No,
are
no,
there
no.
already.
Lordship.
I
once
will bring a
arbitration clause is
specific judgment.
permitted,
I'll bring
they
a
have the
specific
provision
judgment.
to stay the provision of this thing also in under arbitration. So they have to approach the arbitrator,
Yes, under 16, he can
Yes.
stay.
but not now.
You pray
No,
for,
I agree with that, your lordship, but I will.
he has the
I
power
will-
to stay.
What will be the role of the arbitrator if
No, your lordship, the damages will be there, and then the disputed documents, and then the loss of business that we have lost more than a year
If
of
you have
debarment, your
succeed-
lordship.
See,
Hello.
either after it is declared to be bad. that
Well,
it is-
Your lordship.
No, what I'm not getting it. Actually, you are not very sure about the line of submission you have to make in
No,
this.
my lord, I will satisfy your
Your
lordship on
And
Thursday.
also, your lordship, the writ court cannot decide on the disputed question of fact. There is a disputed question of fact, your lordship, which
Well,
requires evidence, your lordship.
This is
Which
purely on the
requires
question of law.
evidence, your lordship, and the matter will be referred to, has already been referred to arbitrator. As such, the arbitrator will be the fit person to decide, and if this,
No, madam, otherwise, blacklisting is adjudicated by High Court and Supreme Court. You have long line of decisions,
Your lordship.
right? Now, what is the question of dispute? What is the question of dispute? You based it, take resort to a document and say that it is invalid and issued the show cause notice, right? He replied and you pass the debarment order, right? Now, at the time of, there are many things, at the time of issuance of show cause notice, because blacklisting is considered to be a civil debt. It is the highest punishment. like life imprisonment in criminal cases. So for a contractor, his whole, because it has a cascading effect. Because once your party is blacklisted, he'll not be able to participate in all other similar businesses in the same name, right? So it has to fulfill some requirements of law, that is odi alterum partem, Irish principles of natural justice. So show cause notice is the stage, right? That he should be given the opportunity of meeting the allegation. And that requires, right, few things to be incorporated in the show cause notice. And I am asking both of you, that is what that a show cause notice should contain. Now, tell me whether it fulfills the requirement of show cause notice. If the show cause notice is bad, every consequential action is bad. Right? Irrespective of his invoking the arbitration clause. Tell me that what is the requirement? It has been, law has been laid down. Because you have been submitting both together, and now it is difficult for me.
Your Lordship, when he has already availed the alternative remedy, can he come to the writ court, Your Lordship?
No, what remedy he has?
Yes.
Show me the
Yes,
letter
sir.
invoking clause.
Your Lordship, he has filed the arbitration petition.
No, he sought arbitration, right? Now, on what ground? He might have written to you. Huh? Writing what? Writing what?
Not a really referred for arbitration.
For what? To decide?
For the purpose of the department letter, Your Lordship.
Huh?
For the purpose of department letter, which we will issue.
Hmm.
That is his way also before the
Hmm.
arbitration petition also. He also referred to the arbitration petition again.
Lord, I have a sincere request. Lord, may kindly consider.
Satisfy me that show cause notice.
Read the last.
Okay, it is not time. Will come out after.
Can we continue on Thursday? If my lord may.
No, no, no,
Your
no.
Lordship, then the matter will be taken up on 27 January itself, Your Lordship, as I'm from outstation. And with Your Lordship.
That will continue today, my lord. Like my learned friend, I cannot come, and then of course, my client.
Not
cannot
Thursday
come.
because Thursday we've been doing a division bench, some other matters.
Lordship.
Or Your Lordship maybe.
That will continue, my lord, because
After lunch.
my client has been blacklisted, yes, lord. My lord, obliged, your lordship. Yes, but. So, two things. Whether the focus is right or wrong, as well. The other thing is, when there's an arbitration clause. Arbitration clause is to be held. Then. Why should we delay it for a very long time? We don't know when the arbitration proceeding is going to be. It's not that we are not aware that blacklisting can temporarily be stayed. But what if the arbitration proceeding begins towards the end of the next year, 2025? When the department is still operating, so they have nothing to lose, but we are losing a lot. That's why. So we have a look at whether the proposed procedure is correct or not. Here also it is reflected, but then it is. Don't say that this is.
এই 1 আর 2 কোন আইছে জানেন 1 2 1 2 বিছনার পড়া
হ্যাঁ?
বিছনার পড়া
Lucio.
Sino? Lorasa. Ora,
Mikey, Mikey.
lagi, matay sila yung tuloy dyan.
Kung ito la de.
Oh. Mo itu lah pada di inti long cuman.
Inti nung jum hai na.
Ay,
Asan ni.
kung na sila matay sila. Alag ng budget na eh.
Apne item 1 2 दिखाना है ना.
Kasi, most of taxi ate. Inti long cuman pada di siya. Kati di ba na?
Iko na yun. Oh, wait.
Free from the government. Then, with the arbitrator. What we want is, if the arbitrator finds us the. In the proceeding before the arbitrator, we are found to be. There have been slavery or not. About the interdiction to blacklist of the law, whatever language. But the government is not really sure. So. The question is. So.
Oh, mention brother, only Uday. Brother, they kill it. Family section, right? So, Uday is- You decide. Yes.
Yes, Mr. Seki. Shall we continue with all the three? We'll decide all the three. Because you give a sequence of events. Because we propose to take all the matters, since all are fixed. If we find that the arbitration proceeding is not required, we'll not continue.
Hello?
It depends on the sequence of events. actually, because you are litigating on 3 forms. Right? We have to decide all which one is.
Your
Because
lordship. My lord, as far
see,
as we are.
first, there is a civil suit,
My lord,
right? I have not checked everything. There is a civil suit. Then there is a, you have invoked the arbitration clause. Thirdly, you have prepared a repetition under 226.
yes, your lordship,
Now, all 3 cannot go together.
my lord,
So it has to be one.
my lord.
Now, I don't know, I have not seen anything. We have
Lordship,
just heard.
Lordship, if we tell on this item number 13, make things more clear.
My lord, before my learned friend make a submission, if I may be allowed to say one thing, my lord. Now, as far as arbitration is concerned, to go for arbitration proceeding, none of us are averse to it. We are all agreeable to it. Number 2, my lord, the writ petition, for the purpose of filing the writ petition is, since we are going for arbitration, at least give us a short period of reprieve, that if we are found guilty or if we are found to be wrong,
No, you have to, before that, you have to tell me one thing.
My lord.
I don't know, Arbitration Conciliation Act. Whether an arbitrator has the power to
My lord.
state a blacklisting and
Yes, sir.
yes, your lordship,
show me some decision.
that is there, my lord.
Section 17. 17 of the arbitration.
Hmm.
Interim measure ordered by arbitral tribunal.
Yes,
Otherwise, unless otherwise agreed by the parties, the
which
Arbitral-
one, which one?
section 17.
17, yes.
Unless otherwise agreed by the parties, the
No, it is amended. Unless otherwise is gone. You are holding an old act. It has been amended in 2016. We are in 2024. Unless otherwise agreed, that is gone.
you're not like amended petition, a party may during the arbitral proceeding apply for to the arbitral tribunal for the appointment of a guardian for a minor or a person of unsound mind for the purpose of arbitral proceeding. Point number 2. For an interim measure of protection in respect of any of the following matters, the preservation, interim custody or sale of goods which are subject matters of the arbitration agreement.
Here there is, A is not invited because there is no goods
Yes,
involved. B. Let us go one by one. So B,
securing the amount in dispute in the arbitration.
nothing there,
Nothing.
nothing is here.
CC. The detention, preservation, or inspection of any property or things which is the subject matters of the dispute in arbitration, or as to which any question may arise therein, and authorizing for any of the aforesaid purpose, any person to enter upon any land or building in the possession of any party, or authorizing any samples to be taken, or any observation to be made, or experiment to be tried, which may be necessary.
C is also not attracted. D is also not attracted. Now the E will come in.
Yes, Your
My
Honor.
lord.
Such other interim measure of protection as may appears to the arbitral tribunal to be just and convenient.
Now, next question is whether, suppose he refuses. Arbitrator refuses
Yes, Your
to stay the debarment order. I don't think there is a provision for appeal.
Yes. Gotcha.
Section 34, Your Lordship.
Section 34. That is final. It will be at the time of final arbitral award.
The order will be.
See, think yourself. You introspect, because if suppose the arbitrator refuses to pass any order of stay
Your lordship.
of debarment, then arbitration takes, say, 2 years' time.
My lord. That is the apprehension, my
3 years
client.
is over.
Your lordship.
No, if you are seeking only the arbitration proceeding against the debarment order, against the order of debarment, blacklisting. Yes. Right, that is one. Before, it is, you are pursuing that only. Right. Secondly, you are also approaching this court, 226. On the other hand, the civil case, also, your prayer was what? On the basis of that only.
That is already the civil suit, your lordship. It
No,
was
litigation is pending here.
Yes,
Mr.
your
Akbar.
lordship. Hello.
And it is not you, it is them.
My lord,
Right.
your lordship.
So we can go whole hog because that appointment of arbitrator may be null and void at the.
No, my lord, as far as, my lord,
See, otherwise, court cannot close its eyes that you are litigating on 3 fronts. That is also creating privacy a bad picture projecting.
your lordship, before the arbitral tribunal, it will not just be on the issue of debarment. For more than a year, we have lost business as far as this company is concerned, your lordship. So we also have other claims, and we are also not averse to it if the airport
No, what is
authority
the,
acts.
show me the invoking arbitration clause. Notice. See, you cannot go beyond your pleading right now.
No,
You confine to it, confine yourself to what you have stated already. When notice was issued in blacklisting,
11/9,
11/9.
2023.
2023, my lord, yes.
Your Lordship,
1 minute.
apologize, Your Lordship. It's 17 July, Your Lordship, proposed notice.
No, blacklisting.
Oh, blacklisting.
No, show cause notice.
No,
Proposed 17 July 2023.
page 55, my lord, of my writ petition.
Mr. Seki, we please take up that arbitration petition.
My lord.
Come to page 55.
55. The arbitration petition.
Hmm.
Your lordship.
55.
The confidential document, 3rd March 2022.
Hmm.
Your lordship.
It was a letter to you. It was a letter to you. It was a letter to you,
Oh, your lordship.
right?
Yes, your lordship.
You are supposed to submit those documents regarding Kulu bus terminal, right?
My lord.
Then next page. Again, a reminder.
Your lordship.
Then page 57.
My lord.
Again, a reminder,
Your lordship.
right?
Your lordship.
Then page 58. Then 59. Let us read your
Your lordship. May I read, my lord? To Shri so-and-so, General Manager, Airport Authority of India. This letter is dated 14 June 2022.
You are diverting it. You are making a departure. Please furnish me complaint letter. Instead of TDS certificate, purchase invoice, electricity bill, water tax, municipal tax, space rent paid, any other document of government agencies, page 55. You were asked for, but in page 59, you please give me the complaint letter. I'm woman entrepreneur, small proprietorship business. I must not be bound to submit any documents without my complete understanding of the matter. I'm informed that representatives from your department have already made a couple of pages, taken picture. ISBT Kulu for so-and-so, survey. So you're diverting the attention. Then 1st July, page 60.
Your lordship.
Experience certificate to substantiate physical existence of cafeteria operated by your farm at Kulu. Demonstrate final opportunity. Thereafter, it is the show cause notice. Issue raised by our opposition, competitor, then show cause notice on 17 July. So you are quite aware about the allegation brought against you by the Airport Authority of India. Now let us see your reply. These documents are part of the writ petition or not?
Yes, your lordship.
Same documents are part of the writ petition.
Yes, your lordship, as far as the, yes.
Let us see your reply. Page 66 is your reply,
Your Lordship.
24 July. And 29 July.
Your Lordship, if
When
we-
I'm saying don't interrupt, how much practice you have put in? When I'm interacting with him, don't interrupt. It is ditto, page 68,
Well,
nothing much. You just ask, withdraw the show cause notice. Then page 70. Let us see your repetition.
well, Look, may I take a look at the page 79, letter to invoke.
No, I am looking at everything.
Hello.
Yes, page 70,
79.
79. What is this page 69? To the readers.
Page 69, your lordship, is part of,
Tender document.
yes, your lordship.
Where is that 1 year? 1 year experience. Not there.
Lordship, this annexure was made to show the clause 11C, which was invoked by the correspondent authorities, my lord. 11C.
Where from you are saying, madam, that the company was incorporated only in
2017.
17? Which document you are referring to? Where from you are seeing? Is it part of the document or outside the document?
Your Lordship, the document is annexed in civil revision 17, Your Lordship.
Civil revision 17. Why not in the requisition?
The petition was filed.
And you have the affidavit in opposition.
Yes.
Why you choose choose method? Something here, something there. Huh? Which page?
Page 247, Your Lordship.
Civil revision.
Item 13.
Mr. Seki,
My lord.
come to their affidavit of opposition in the repetition. Course. Page 10.
Lordship. Second paragraph.
Second para. You revert tomorrow. We'll take up.
My lord. I'm grateful, your lordship.
Thursday.
Lordship.
That's all. If you can rebut it by addition, substantiating some document, otherwise everything falls apart. Because your certificate, experience certificate is 3 years, 2014, 15, 15, 16, 16, 17, CSA, Infratech Private Limited. Right?
Your lordship.
And Ministry of Corporate Affairs website says date of incorporation is 11/8/2007. Everything falls apart. But I am giving you 24 hours opportunity. Going here and there is not going to do anything. Instead of hearing the submissions, I should have checked the documents myself. Fraud goes into the root of the matter. Fraud vitiates everything. And you have been given ample opportunities to produce documents. You have been given ample document. I have seen it from the arbitration petition as well as from this writ petition. But you are my competitor, my rivals, your reply is that instead of producing the documents which have been asked for, it is clear this performance document certificate is of 2014-15 by Sandeep Mann, and the letter from the AAI asking you to produce documents starts from, you have been given personal hearing also. It is not that only so-called. And you are resorting to, you are abusing the process of the court on 3 fronts. 3 fronts. Come to page 59. So many documents. TDS certificate. If you are operating a cafeteria in Kulu, then at least space rent you have paid for 3 years. There should have been some document. TDS certificate, if you're operating for 3 years, TDS certificate should have been there. Space rent paid, that is, you are paying it to the transport corporation, rent, or somebody. But since March 2022, till the debarment order, you are not paying anything. And this document, at least here and there, this document is clinching 247 in the middle, date of incorporation. Company is CSA Infratech Private Limited. $247.
Yes, your lordship. 11/8/2017. Anyhow, your lordship.
So I am giving you 1 day's time to rebut Ministry of Corporate Affairs document.
Lordship, I
And
will consult
statement.
my, yes, your lordship. I will
No
consult my
further.
client.
No further time. I have spent enough time.
Your lordship. I'll consult my client and try to satisfy his
Tomorrow.
report, your lordship.
Yes, definitely. But so far as you rebut this statement, not from the knowledge, from the record.
My lord.
This cannot be rebutted
Yes,
by
Your Lordship.
knowledge,
My lord-
from knowledge.
Yes, Your Lordship.
Am I
My lord-
clear?
Yes, Your Lordship. What I know is that, Your Lordship, an organization can function without registration also, but we do
No,
not know.
this is, see,
yes,
this
Your
is a
Lordship.
private limited. Go through Companies Act. When a entity, when can an entity write as private limited? When public limited. And two directors mean it is private limited. For a public limited company, at least there should be 10 directors. Right. And others, shares are, stakeholdings are different. But two can form a company. Husband and wife can form a company. But question is when that private limited company was incorporated. If it is 2017, they cannot certify ex-specie for performing cafeteria, operating
Before they
cafeteria
came into existence.
under their cover. Because they say, we are the concessionaire in the certificate and you operated under them. But they issued the certificate as a company. Had it been a partnership firm, it would have been a different thing. So, you rebut by tomorrow from record, not from knowledge.
So on Thursday, my lord.
Thursday will take up all three cases.
Lordship,
Because I have seen the order of the learned principal district and session judge till the disposal of the,
Arbitration policy.
that I think does not stand in our law.
That's why I'm not disputing your.
Right, you have fairly submitted, your submission is fair to that extent.
Lordship on.
I'm admitting it.
My lord.
Lordship in item 13, which is marked as civil revision.
Will not go for that order of arbitration today. It will be posted again. Thursday. May not be. Then he will go for arbitration. We'll pass the order on Thursday. On
Lord-
arbitration.
Lordship, in item 13, I'm the revisionist. So here, he will be the respondent. So the matter is that the lower court below have passed a judgment in IA 76, where he disposed IA 69 also. In the same time, in the same order, in IA 76, he have passed that to go for the arbitration proceedings. More so, he have stated the
Which
has
already.
interim order, where now on.
No, not in the civil revision. You have silenced that order.
Yes, sir. And it is-
Then
Yeah, like I'm supplementing my case in with two citation of. So
Okay. reserve it for Thursday. Let him rebut. We'll take up all the three. And we are postponing that order of on arbitration till Thursday.
My lord, I
No,
think the
no,
lordship
well-
will at least make that survive because.
That may survive, that will be reiterated on Thursday.
My lord,
Because I have heard already, almost subject to your rebuttal. And I have seen your replies also. Because it is not a show cause reply, show cause notice. It was preceded by many letters. And during the show cause hearing, you were given personal hearing also.
Yes.
Blacklisting is a serious issue. But question is whether it is based on. I thought that initially that this show cause notice might not survive. But after going through previous notices, please furnish, please furnish, please furnish, and your reply. That does not indicate that you are not aware of what is going on. But my rival, my competitor, my so and so, You are asking for complaint, but not at any time saying that these are the documents. Take this, close everything. It is not your case. Had it been a case, yes. And this Ministry of Corporate Affairs, we can take judicial notice of it. Right, and there is a statement, specific statement. In paragraph, page 10, you rebut them. That's all. Heard Mr. Joshua
Yes, Your Honor.
Seki, learned counsel for the petitioner in item 11 and 12. And for the respondent in 13. Also heard Miss 11, 12, who are appearing?
Your Lordship, I'm appearing in 11 and 12.
And you appear?
Item 13.
KV Nagi.
V. N. Kara.
Also heard Mr. V. N. Kera, learned counsel for the petitioners in 13. And MS? Name? P. Chetri, learned counsel for the respondent AAI authorities. In the petition, in 11 and 12. During the course of deliberation, the cases are the genesis of these cases is a performance certificate issued in favor of Messrs. Sana Enterprises on 23/3/2018 by Messrs. CSA Infratech Private Limited, certifying that Messrs. Sana Enterprises operated a cafeteria stall at Kulu bus terminal in Himachal Pradesh for 3 years during 3 years, 2014-2015, 2015-2016, and 2016-2018. 2016-2017. Full stop. In the writ petition, WPC number 232/2024, the respondent AII authorities where it is in paragraph 12 has made a categorical assertion that from the website of the Ministry of Corporate Affairs, Government of India, in the website of the Ministry of Corporate Affairs, Government of India, it is shown that Messrs. CSA Infratech Private Limited was incorporated on 11/8/2000. Not, madam, you are wrong. Okay, 17. 17. Full stop. Mr. The petitioner, full stop. In the what do you say? What is this? 247? How do you name it?
Incorporation.
In the from the in page number 247 of the civil revision petition number 17 of 2024, the petitioner has annexed the company stroke LLP master data from the website of the Ministry of Corporate Affairs, Government of India, in respect of the company named CSA Infrastructure, Messrs. CSA Infrastructure Private Limited. Showing when the date of incorporation of the company is shown as 11/8/2017. The petitioner in WBC number so and so on, where short for is granted time till today. File an affidavit in opposition in rebuttal to such fact asserted by the respondent, asserted by AAI authorities as indicated, as mentioned here in above. First of the challenge is made to an order of debarment dated of Messrs. Sana Enterprises for a period of 3 years. Closed up. As the aspect indicated here in above is of will have a vital bearing as now release the cases on Thursday.
Lordship, interim will continue to operate.
The interim order passed in CRPs, civil division petition, so and so shall continue till that day. Next day.
For admission, item number 14.
Kohito Achomi.
Yes, your lordship.
Yes, sir. First date. Only returnable date, okay. You are enjoying interim order? Enjoying interim order?
Yes, your lordship.
Yes.
Oh, maybe your lordship. Your lordship, I'm mentioning for my senior, you know, responding number 5. Lordship, we are yet to receive an inspection.
Okay, how much time?
Few weeks, your lord.
You represent all the respondents?
No, your lordship, responding number 5.
And what about the state respondents? Who appeared on the earlier occasion?
Your lordship.
LT Sankam.
Yes.
LT Sankam, learned additional AG. Any state council? Any state council representing Nagaland? Their response will be required.
Yes, your lordship.
Mr. Joshua Seki, learned counsel for the petitioner. Mr. Des, representing Mr. LT Sankam, learned additional advocate general Nagaland for the respondent number 1 to 4, and Mr. Jingyapong, learned counsel representing Mr. Yangarvati for the respondent number, learned central government counsel for the respondent number 5 are present. Full stop. You need how much time?
few weeks.
both Mr. So-and-so and Mr. So-and-so. Both Mr. So-and-so, learned state council for the response number 1 to 4. And Mr. So-and-so, learned council, for the response number 5, have prayed for. And are granted 4 weeks time to file their respective counter affidavits, full stop. The interim order passed shall continue till the next determination. Mr. Jimomi, LT's outcome used to appear in this case. He accepted notice. So he Jimomi representing Mr. LT, London State Council. 4 weeks time granted to file affidavit. Interim order continued.
For hearing, item number 18.
With this in the 3 cases. This one also, and this one also inside that file. Item number. Service, yes. Yes.
Let me be leadership.
Most of your private respondents also don't honest.
Huh?
Newly implemented.
Newly implemented.
Notice to the newly implemented respondents
Huh.
has been taken through the DGI. Language and also language. And they are also they are not in that, and they are also state country.
By which order? Affidavit of service. Newly. Same. Which order? 27/3/2024. 27/3/2024.
Yes, 27.
1 minute. Yeah, I number 34. Hmm. Any affidavit of service?
Yes, I have my adversaries.
Huh?
I filed my adversaries
Affidavit of service,
on 14/8/2000.
14/8.
All of them, they are serving outside the state.
Hmm.
So most probably they come during the vacation also. This document.
They are otherwise served. I have seen. Order dated. Hmm. Yes, it is held to be served. Yes, obedient is.
My lord, the sick, my lord, prevents raised here in the present issue is my lord, recruitment relief, which was conducted in the year 2012, my lord, by the Assam Rifle Department.
Oh, yeah, in 2024, yes.
Yes, my lord. It has been long, my lord.
Huh?
So petitioner had participated, my lord. The relief had taken place, my lord, in the Mapur, my lord, in the state of Nagaland, my lord. And petitioner admittedly, my lord, qualify in all the stages of examination, my lord. There is no dispute to that, my lord. And my lord, in the year 2016, by imbuing order 22/7/2016, my lord, annexure 8, kindly see page 64. That's what I was communicated, that since I was found to be low in the rate, so my appointment, I could not be appointed against the notified post, which are specifically mean for ST category for the state of Nagaland. That was the brief background. Now,
Hmm? Low in merit.
yes, madam. Page 60.
Take me to the previous events. Previous events.
My lord. An advertisement was issued, my lord, in the year 2012.
Hmm.
The next one is the calling letter, my lord, page 56. That was an calling letter issued to the petitioner. Accordingly, I participated, my lord. And I have qualified, my lord, in all the stages. My lord, there are 5 stages in the recruitment really. Can we see, my lord, the stages? We'll find, my lord, from there, my lord. If it a bit in opposition, my lord, there is a rule how a recruitment has to be conducted. My lord, we come to page
Affidavit of
opposition by a respondent, my lord.
respondent.
Yes, my lord. Page 27, my lord. For my lord, Roman 5. First, a candidate has Hyde Park.
Page 20.
In the first stage, page 27, my lord.
Hmm.
In the first stage, there are 5 rounds, 5 stages of examination. In the first stage,
No.
first
27, which part you were reading? Tell me.
Roman 5, my lord.
Roman 5, at the very beginning.
Height part. A candidate will be assessed that about his height. And if
No, Roman 5 at the very beginning of the recruitment process.
my lord, this is the stages of examination. How
No, read it. You might have read it
Yes.
n number of times. I'm looking at for the first time.
Yes. At the very beginning of the recruitment process, candidates whose OMR application are found to be in order will be asked to go through Hyde Park, and hereby candidate with lesser height will get eliminated. So firstly, I have to qualify myself regarding my height. Now, then thereafter, there will those who qualify the height test will be subject to 5 kilometer race for male and 1.6 kilometer race for female to be completed within 4 minutes and respectively. So in case of female, male, 5 kilometer, I have to complete
Okay.
within 4 minutes. Now
You are male or female?
I'm male, my lord.
Oh.
So within 24 minutes, I have to complete. Now, next, my lord, Roman 8, modern biometry. Those who qualify in the race will be subject to modern biometry method. To prepare impression, that biometric methods includes that those types of validity. In the absence of the method of identify marks in the body may be used. So next, that is the next stage now. Then testimonial of the candidate will be checked after identification process, and only eligible candidate will go the next step. So according, my lord, this is the first stage in my perception, my lord. Then next round, my lord. Candidate, come next page, my lord. Page 3 here. Physical standard test, BST. Candidates who are found eligible on screening of testimony will be screened first for height, chest, and weight measurement by a poll before sending them for BPT. Next, my lord, third stage, third round, physical efficiency test. The candidate who clear a PST will be required to undergo PD. The bed consists of the following. For female, male, 11 feet long jump, 3
Okay,
chances.
you skip for female.
Yes,
You skip for female.
yes, male, 11 feet, 10 high jump, it will be 3.5 feet.
Okay.
Next, my lord, can we note below that may be important, my lord. Physical efficiency test will now be only qualified in nature and will not carry any marks. Which means all those physical efficiency tests will not carry any marks. Now, my lord, this is the now 4 stages. This is the written examination, my lord. The candidate who qualify in the PET will be required to appear in a written test. The written test will consist of only OMR based, objective, type, multiple choice question to be answered using a pen. A question paper should be of 100 marks and it will comprise of at least 100 questions. Now, my lord, D may be relevant, my lord. This is the subject matter in which 100 question marks has to be allowed. Yes, my. Then, my lord, this is the old stage. Now, my lord, next stage kindly see page 30. Page 30. This is the 5th stage, meaning thereby last stage, medical examination. The candidate will be medically examined to assess their physical and medical fitness as prescribed in the eligibility condition. Medical examination will be conducted after written exam. This is important. Then number of candidates to be examined will be equal to the number of vacancy increased by average failure rate during medical examination determined on the basis of past experience. My lord, this is important, my lord. In case of medical examination, temporary unfitness should not be allowed and the candidate declared unfit may be examined by appeal panel on their representation to be filed within 15 days of rejection by the medical board. The appeal should be decided within a month on the date of rejection. If found medically fit by appeal panel, the candidate will be recruited against wastage. This is the last stage. My lord, then how merit has to be drawn, my lord. This is clause 13. This is important, my lord. Merit list in each category, namely general, SC, ST, MST, my lord. OPC and ex-servicemen will be drawn separately in respect of each state, union territory on the basis of aggregate marks obtained in written tests. Then, my lord, clause 15, final selection. The final selection of candidate will be made in order of merit in each category. The cutoff percentage mark for appointment will be as follows. Now, my lord, since as per the stages, all the stages, my lord, I participated and I have found qualified, my lord, even in the medical test also, my lord. There is no report to show that I am not qualified in the medical test, nor in the written exam. Now, when the matter starts situation, my lord, I have been waiting bona fide, my lord, for my appointment. We hope that my candidature will be considered, my lord. Since I qualify myself, my lord, in the recruitment training. This improvement letter order has been issued, my lord, in the year 2016. So accordingly, my lord, in order to justify, my lord, the contention, my lord, in order to enable me, my lord, what marks I have obtained and on what basis I have been categorized as low in merit, my lord, I hereby prefer an RTI in application. But unfortunately, my lord, I could not, my lord, assess the information as sought by me, my lord. On the ground that, my lord, it was informed to my advocate that the information which you sought pertain to third-party information. So we could not give you, and moreover, section 24 and section 2 is exempted since Assembly Police is exempted. So we could not provide you. So the applicant himself also filed an RTA application, but does that, my lord, if NSS, and initially, my lord, I have approached the learned at my lord Central Administrative Tribunal, my lord, and my lord, finally, my lord, when the after admitting the method for final hearing, my lord, finally this order was passed, my lord, page 87, my lord. So since on the ground that the tribunal does not have jurisdiction, so I have been, the tribunal does not have jurisdiction
Why?
when them is matter relating to my lord Assam Rifle Department.
Hmm.
So that
And
OA has been
armed tribunal does not have jurisdiction.
OA has been, my lord, withdrawn with liberty to approach this honorable court.
Was it armed tribunal does not have jurisdiction?
My lord, Central Administrative Tribunal.
Armed forces tribunal.
My lord,
Assam Rifle does not fall under,
so this petition has been, my lord, immediately filed, my lord.
When did you file this OA? 2018.
Yes. Yes.
Why it should not be dismissed for delay and laches?
No, my lord, with due diligence, I have been pursuing my remedies, my lord.
What? Before whom?
My lord, initially, my lord, I also filed an application. My lord, stating that if in a communication has been made, I'm hailing from remote area. So might have been not have been reached me. And I number of occasions I make a representation. And only in the year 2016, after 4 years, they come up with a new order, which is under challenge. So I filed an RTI in the meantime, in order to, my lord, to know what marks I obtained, what other candidates obtained, on what basis I was doing.
All the results were declared, Mr. Yangavati? You said that the results were declared on 15/10. In your affidavit, you have annexed an affidavit placing on record the results dated 15/10/2012. Now, where is the petitioner's name, Mr. Muri? Serial number? What is your name?
987.
The serial number 987.
And Timo.
And Simo. And how many were recruited?
The question is the post, there was different posts. I think it's reserved for a general, for the STSC. And he obtained only 44 marks.
He is ST. Now, in the serially, in the seriality, what principle we follow? If the ST candidate on his own merit gets into the general category, he will be treated as general category?
No.
Huh?
He are under ST category.
So his position among ST category is what?
Below 11, is not below.
Tell me.
So, can you allow me to?
Just 1 minute. How many posts you say?
12 posts.
Total.
The whole is 25.
25.
13 for
Unreserved.
general.
Open. General. Okay.
ST, SC.
12 for ST, SC.
And if my lordship may come to the marks obtained in my affidavit, page 4, start on page 4.
Page 4. One is small affidavit.
The result.
Result. This one. This one.
Yes. If my lordship may come to page 4.
Page 4.
Yes. Yes. For Nagaland, It starts from serial number 977. Lordship, I can take the
Yes.
serials.
977, tick.
977,
Yes.
we got 52 marks,
Hmm.
and 980,
980, 977,
977,
978,
978,
979.
978, he got, he's below, the petitioner. So I will record his,
Okay, okay, okay,
979.
okay, okay.
his mark is above the petitioner.
Ah,
981, no, 980,
uh,
980.
979 is also.
Yes, 979 also, 16. And 980,
980, yes.
then membership, 983,
I don't just for convenience, I just reproduce extra copy.
983. And 987,
98,
985,
985,
985 years. Then 987,
987. He is okay, 987.
yes,
He is 987, I think.
yes, he is 987.
Ah,
Then 990,
990.
990,
And what about 989? What is this
yes,
over?
989 also. 989 also. Then 994 also.
No, he's general. Pipal Singh, Lalit Kumar.
Yes, yes, it is in general category, sorry. And 103 is over here.
Maybe 1003.
Yes, 003.
Hmm? Then
1006.
hmm,
So these are the
Nagaland.
candidates from Nagaland. Also, these are the candidates who has obtained higher marks.
one more. Nagaland. 1034. Nagaland. 1034.
It's 1041.
1041.
1041.
Hmm?
Yes, 1041.
Then 1043.
1043 also, yes.
Huh?
Yes. And next is
ST.
1057.
Hmm.
1053, I think.
1053 is
Yes.
38. 38. He's
Yeah,
38.
it's below.
Below,
is
below.
the-
Below.
It's below the division. And
1082.
1058.
58
Yes.
through 58. Then 1082. 1082.
1082.
Then 1084.
1084 also is. Then
1091.
it's general 109 is.
No, he's ST. ST. Against his name.
What is this? 1091. Yes.
Then 1108.
1108.
Hmm. Nagaland. 1119. 1121.
1121.
Then again, 1126.
1126.
1125 also.
1125. 1126. 1127.
Then 1128 also.
Yes. Then 1130. 1131. 1132. 11.
So tell me how many?
So
My lord, that was the extract copy, my lord.
How many? How many? Tell me.
Yes, many.
Above 44.
No, no. My
You
lord,
got how much?
My lord, my contention is.
Contention will later on.
No, no,
First,
as
the
per the report,
as per the statistics.
as per the statistics.
Statistics. You scored how much?
55 candidate they have declared.
44. You scored 44.
Yes, ma'am.
You scored 44.
Yes.
Is it correct or not?
Yes, that is the contention, my lord, as per report.
Contention will come later. Let me be clear about the facts,
Yes, yes,
Mr.
yes,
Counsel.
Yes, correct. So,
Then how many total above 44? From Nagaland ST. You are ST?
yes,
How many above 44?
around 16.
Many. I have counted many. What, Mr. Angirvati? You have not done the homework. 1, 2, 3, 4, 5, 6, 4, 5. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26. At least I have counted up to 25 above you. 25 above you. ST, Nagaland.
So it will come under 26.
At least I haven't counted the later part.
yes, yes.
Tell me what is your case?
My lord, my case is as per the clause. Just we have read clause 12. Medical examination shall be conducted after written examination. And
Are you denying 25 posts?
yes,
Are you denying about filling above 25 posts?
I'm not denying, madam.
And out of that, 13
13
is general category?
13 is ST,
13 is,
not 12. Yes.
okay, none. 13 is okay. Your contention accepted.
Because report on one hand,
Ah.
they said 12.
Anybody,
report said 13.
anybody below you has been appointed? Anybody below 44 marks is appointed?
I'm not saying that, my lord. I'm saying that
That one,
I was not.
no exercise.
No, my lord. Kindly,
Ah.
my lord, allow me, my lord.
You go on.
As per the clause 12, they have to, once a candidate is qualified in the written examination, they will be called for the medical examination as per the notified post, maintaining 1:1 ratio in terms of clause 12. Clause 12 is very clear. So, if any candidate subsequently, my lord, medically unfit, then it will increase. The number of candidates who will be called for medical examination will be increased. So once I was called for medical examination maintaining the 1:1 ratio, they are not denying that MHA 25/6/2009 is not applicable. I will demonstrate, my lord, referring to the affidavit filed by the respondent, my lord. So in terms of that clause, since I was called for medical examination, now later on they cannot say, no, you put law in hearing.
I am putting a question directly again. Anybody below you was appointed?
My lord,
Anybody securing less appointed?
they have appointed us,
Tell me yes or no.
post is still vacant, my lord.
That I am not concerned with. You don't have any indefeasible right to
Yes,
get
correct.
appointed.
Correct.
Don't make submission which is not required to be submitted. Anybody below you was appointed?
That they can
The authority has full discretion to appoint or not appoint. You cannot, just because you got the list, in the list of qualified candidate having scored marks in the written examination, that does not get you any indivisible right to claim appointment. That is the law. Anybody below is appointed, then yes, invoking Article 14, you can approach the court. That's all.
My case is, I was not considered.
Not required to be considered. At least I have found 25 above you.
No, my lord,
Question is that you, just because you secured 44 marks, that does not give you any right to get appointed. It is totally within the discretion of the authority employer. So, just because you are in the list, that does not mean that you will be called to be appointed, right? You don't have any right unless somebody below you on merit is appointed. They can stop. Yes, they can ask for 100 number of vacancies, but they decided after preparing a list, no, this time we'll be stopping at 50. But here is the case, 13 have been appointed or not? Huh? 12 have been appointed. That's all.
The question is whether I am going merit or not.
Low, your merit clear.
Once I am in merit,
You are knowing very clearly.
I might in the career has to be considered. My lord.
Why?
That was not considered. My
Why? If 13 above you has been appointed and 13 is the vacancy for ST, then why you are required to be considered?
The ratio, it's a mandate, my lord.
Man,
Post 12 is a
vacancy is the mandate first.
Yes.
If the vacancy is filled up, end of the matter.
And my lord, proceed mechanism.
And vacancy is filled up by candidates having secured more marks than you, end of the matter.
Yes, ma'am. And my lord, they even against the quota, my lord, they have appointed outside general category, my lord. Very EDBS, my lord.
What?
And secondly, my lord, no merit list has been prepared. Combined merit list they have prepared. In
Show me any
contradiction-
candidate who secured lesser marks than you got appointed amongst
My
those
lord,
13 vacancies. Any names of the candidates are there? Mr. Engarbati, the names of the candidates who were appointed.
These are the private respondents. The private respondents.
Tell me, who are the person appointed? Where from I can say?
My lord, additional affidavit
By whom?
by a respondent, my lord. That were the selected candidate, my lord. Appointee candidate.
Where is that?
All the private respondents who were included, they got higher marks than the.
List of successful candidates. Okay, this is the list of successful candidates. Nagaland. And they were appointed.
Yes, no.
Page for my lord.
Page 4, yes. Who are the ST candidates?
My lord, serial number 13. Manju Hazarika is also appointed against ST. Then, my lord, my kindly see page, serial number 21.
50, his mark is 57. And up to what? Nagaland is up to what?
Serial number 21.
And it ended where? Mr. Yangarbati, please. It ended where? Last appointment, last of the candidate.
Lordship, those candidates who were appointed has been included as the private.
Okay, please tell me from page 4. Where have you stated that these persons are appointed? Please make my work lesser. Mr. Joe, whether I'm disposing of this petition. Passing order. Mr. Muri,
Yes, madam.
you assist. Mr. Angarwadi is not assisting.
Your Worship, at the time of filing out my affidavit, the private restaurant were not completed. So.
No, tell
that's
me
why
from the,
I believe that
tell me from page 4,
Yes.
anybody that from Manju Hazarika up to whom appointed?
Plus 25. This all serial number 1 to 25 are the appointing candidate.
That is what. Total how many? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. These are 13. Up to Kubheni Chijo.
Yes, my lord.
Those are appointed.
Yes.
Then you are L. Lichemo. Your petition also is to be dismissed on another count. Because from the candidates above you are not applicant. Candidates securing marks above you are not implicated in this petition. How many of have been implicated?
My lord, as per the additional.
No, you scored 44. Right? There are 7 candidates above you
My
who
lord,
are not appointed.
my lord, the thing is, report, my
Thing,
lord,
thing is we don't know.
if report is produced, my lord.
Not report,
This
13
This
candidates.
court also, my lord, on last.
Wherein it is said that these 13 candidates is appointed? Tell me.
My lord, in the additional affidavit, my lord.
Huh? Where?
As per the court order, they have been directed to file this affidavit incorporating those persons who were appointed. And accordingly, this has been filed, my lord.
No, list of selected candidates.
Yes.
These are no, serial number page 4 is list of selected candidates. And what is this ORLST? Page 5? Next page. Both of you are not assisting. Both of you are not assisting. Please explain this page number 3, 4, and 5. That's all. I'm asking only that much. What is page 5?
My lord, we do not know, my lord. As per
You do
the
not know, he do not know, court will know.
As per
Huh?
the condition, my lord, that was the.
You do not know, court do not know.
Selected candidate.
Yes, affidavit is missing from my.
Oh, your affidavit is missing now. I am asking simply this information, Mr. Muri.
Yes,
Page 4. It says, over the table, it says that list of selected candidate. Right?
Yes.
And list of selected candidate, I have to know. And this is what? ORL means what?
ORL, my lord, operator radio line, my lord.
Operator
Radio line.
radio
Line.
line
Yes, that is the both I am contesting, my lord.
contesting.
Yes.
Okay. Now page 3, any ORL is there? Okay. ORL. List of selected candidates. VSC means what? VSC means? VAC. VAC released means? Okay. Anything?
My lord.
I have checked myself instead of hearing you.
No, my lord, just permit me, my lord. I'll just rely on the statement filed by them, if it fit. Since number of vacancies is not now settled, my lord, 13, I will not go to that, my lord. Now, closing mechanics come to para 7, page 5
Of
of affidavit in opposition, my lord.
para 7. Hmm.
And second paragraph,
Hmm.
3 plus 3 line, first 3 line, second paragraph. Further, it is also submitted that even after medical examination, candidates are required, are disqualified. The final merit list is drawn if they are on the basis of overall marks obtained in PhD, PET, legal examination, skill test, and medical test. My lord, I'll just pause for a moment. Here, they categorically, my lord, said that to the final merit list of those candidates to be appointed, there has to be drawn, my lord, the overall marks obtained in the PhD, all the stages, in PhD, medical, or written examination, all those have to be cumulatively taken into consideration for drawing the merits. That was what?
Mr.
Okay.
Mori,
My lord.
it is called making hill out of mole.
Yes, my lord. So, my lord.
Making hill out of mole. Or making mole. Making.
Now, my lord, I'm just, my lord, what is contrary, I'm just indicating, my lord.
This is.
Admission part, I will come, my lord. Few their admission part.
What admission?
Admission,
It
my
is an
lord.
admitted fact there are 7 candidates above you in the waiting list also. And all the 13 have been appointed. State of Nagaland were allotted 25 seats. General 12. ST 13. All were filled up by merit. and last of the candidate was 49 and you scored 44. In between, there were 7 more. There were 7 more. Everybody qualified. Mere inclusion of name in the merit list, because your turn would have come if any of the 13 plus 7, total at least 7 candidates were found to be medically or whatever, were disqualified. But they were, unfortunately for you, they were not disqualified. They got entry into the Assam Rifles. So it is a situation which you can't salvage.
My case is that, my lord.
I have heard Mr. enough, Mr.
My lord,
We-
see, my
too
lord,
much.
till today, my lord, no report, my lord. What
Who-
marks I obtained, on what basis I was doing, really,
May-
toward, my lord, it is.
Okay, I am declaring how much you have got. That's all.
Kindly,
I am
my lord.
declaring in the judgment. 44. That's all. What more?
No, my lord, once the medical, my lord, is the only round to disqualify the candidate, my lord.
Damn, you're the qualified candidates
Because
on merit.
they cannot hold me for medical examination, my lord.
No, madam.
That is what the rule says, my
No,
lord.
sir.
My lord, with due respect, my lord.
They are
Rules,
prepared,
standards,
they prepare the list, merit list for more numbers. Suppose if
And-
somebody fails, so that the next in line can be inducted.
And the my lord, the merit list, they have prepare a merit list. They have to prepare merit list separately for both general as well as SD. But they have prepared merit list combined. That is important, my lord. And no publication of merit list, my lord. No publication of merit list, my lord, at all. How they are saying how
I can dismiss your petition, but because of delay also, but I am considering it on merit.
my lord. So, my lord,
That's
this is
all.
about my conviction, my lord. My kindly allow me that this all the citation I prepare, my lord, I will just.
At the end of the delivery, you will give it.
Read
This is
nothing
too
much.
Not written argument. The instant writ petition under Article 226 of the Constitution of India is prepared by the writ petitioner, assailing inter alia an order dated 22/7/2016, and also his non-selection to the post of constable. To the post of constable, please assist. Huh? What is that ORM?
Radio line, my lord.
Operator, radio line, ORL, pursuant to a recruitment rally held in the year 2012. The petitioner has claimed that he belongs to scheduled tribe and an inhabitant of Nagaland, permanent and indigenous inhabitant of Nagaland. It is a case of the petitioner that in the why Constitution Secretary's order? What place has in a recruitment case, Ramana Dayaram city, what place it has? Ramana Dayaram city? For what principle?
Citation.
Your citation perhaps?
Yes.
Huh? Nazir Ahmed, why? When a statutory provision.
My lord, guidance is here, my lord. With your respect, my lord.
Test Prakash Pathak. Recent one. Constitutional amendments. You have studied much. At least,
My lord, I have,
Mr. We have studied.
my lord, I try my best, my lord.
The you have really made not a hill, mountain. What is this?
My lord, regarding.
How many for this?
Status
At
of-
least, how many? 20 judgments. 20 judgments. I don't think by 20 judgment you will be able to intimidate me in such a simple case. Where is your actual case? In the writ petition? Where is your actual case? Okay. From para 10. In the month of October 2012, comma, an advertisement was made for inviting applications for regular selection and appointment in vacancies in the post of operator radio line ORL trade by the respondent number 4. Full stop. As per the said advertisement, comma, the intending candidates shall be required to qualify in the physical efficiency test PET as per the standard and procedure prescribed under the Assam Rifles rules, 2010, framed therein. It was mentioned in the advertisement that only those candidates who were found eligible and qualified in the physical efficiency test PET would be called for participating in the written examination to be conducted by the selection committee, comma, duly constituted for the purpose. Full stop. In response to the said advertisement, comma, the petitioner submitted his candidature. Full stop. On his application, being found complete, the petitioner was called to participate in the recruitment drive. Full stop. It is the further case of the petitioner that he received a call later from the respondent authorities, whereby he was asked to report at 7:07 hours on 15/10/2012 for the written test. Full stop. On receipt of the said call letter, the petitioner duly appeared in the written test. Full stop. Thereafter, the petitioner, who was allotted candidate ID number 3196, was informed by another call letter for medical examination that the petitioner had qualified in the written examination conducted at Dimapur, and he had to report for medical examination test at the Assam Rifles Composite Hospital within bracket ARCH at Dimapur at 7 hours on 11/12/2012. Full stop. The petitioner accordingly appeared before for the medical examination test at the time, date and venue mentioned by the respondent authorities, and according to the petitioner, the petitioner was found medically fit in the medical examination test by the medical board. Full stop. Thereafter, the petitioner, being confident of receiving appointment in view of his performance in all the segments of the recruitment process, including the written examination and medical examination test. But during the subsequent period, he did not receive any information offering him appointment for the post of operator radio line ORM. Post of. Next paragraph. The petitioner, in view of as he has not received, as he had not received the final results of the recruitment drive wherein he participated, the petitioner submitted representations before the respondent authorities on 22/7/2013, 20/02/2014, 9/9/2014, 3/3/2015, 14/7/2016, and 14/7/2016. It was in response to his representation that is dated 14/7/2016, the Office of the Directorate General, Assam Rifles, Shillong, informed the petitioner provide its letter number, page 64, dated 22/7/2016. First of, in the said reply on the subject, quote unquote, enrollment into Assam Rifles, the petitioner was informed that it was Assam Rifles recruitment rally, not drive. Assam Rifles recruitment rally. The responding authorities acknowledged the attendance of the petitioner in the Assam Rifles Recruitment Rally 2012, within bracket technical, at Dimapur, Nagaland, for the post for the trade desk operator radio line against ST category. First off, the petitioner has further been informed that he was found low in merit against the vacancy allotted for the state of Nagaland. It had been clarified that the petitioner scored lesser marks in the written examination from the other candidates who were selected against available vacancies. After receipt of the reply dated 22/7/2016, the petitioner sought information in respect of the Assam Rifles Recruitment Rally 2012, more particularly about the selection made for the trade ORL from the respondent authorities under the Right to Information Act. It is the case of the petitioner that the information the petitioner sought for under the Right to Information Act 2005 was denied on the ground that, what is the ground? Denied on the ground that no third-party personal information can be provided under Section 8 within bracket small j of the RTA Act 2005. The petitioner thereafter approached the Central Administrative Tribunal, Gauhati bench, by filing an original application against his non-selection postdoc. The said original application was registered and numbered as O A stroke 46 stroke 303 stroke 2018. In the said original application, the petitioner challenged the impugned letter stroke reply dated 22/7/2017, by which the petition was declared as low on merit. Later on, the original application was dismissed on being withdrawn with liberty finding that the tribunal had no jurisdiction to adjudicate on the issue involved. Para being with person to the liberty granted by the land Central Administrative Tribunal, the petition has preferred the instant petition seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India by this regulation. First of, I have heard Mr. N.K. Muri, learned counsel for the petitioner, and Mr. Yangirbati, learned counsel, learned central government counsel for the respondent number 1 to 9. Full stop. During the course of the proceedings, comma, it was revealed that it was found out that during the after completion of the Assam Rifles Recruitment Rally 2012 technical held at Dimapur for the trade ORL, comma, 13 number of candidates were appointed against the scheduled tribe category. Post of. The petitioner, though initially the petitioner did not include those 13 number of selected and appointed candidates, comma, later on, comma, the petitioner implemented those 13 selected and appointed candidates for the trade ORL against ST category as respondent number 10 to respondent number 22. Post of. The respondent number 10 to 22 were thereafter served notices through the respondent number 2. As the respondent number 2 has served a compliance affidavit to that effect. Post of. During the hearing, none from the respondent number 10, none from the respondent number 10 to respondent number 22 was represented. Post of. Para. Mr. Muri, learned counsel for the petitioner, has submitted that there is a scheme for recruitment of constable in Central Police Forces. Full stop. The procedure to be followed for recruitment has been laid down therein in detail. Post of. We have submitted that there were a number of tests. There are a number of tests held in a recruitment process and a petitioner had qualified in all the tests, specifically referring to medical examination, specifically referring to the process of medical examinations. In the scheme. He has submitted, Mr. Muri has submitted that the candidates are medically examined to assess their physical and medical fitness as prescribed in the eligibility conditions. Full stop. The medical examination our medical examination is conducted after the written examination, and the number of candidates to be examined is equal to number of vacancies, increased by failure rate during medical examination determined on the basis of past experience. Yes. Anything more?
I don't, well, 12, 13, 14, that is my case.
That is 12, medical examination 12. Is it not?
Clause 12 is the medical.
Ah.
And clause 13 and 14 is regarding that how to prove merit list.
According to Mr. Muri, the respondent authorities did not prepare the merit list in conformity with clause Roman 13. Subclause or clause 4. One, 2. Clause so and so of the scheme of selection. Full stop. Record Mr. Muri has contended that had the procedure followed for final selection been followed in letter and spirit, the petitioner would have been selected and appointed to the post against the trade ORL. How many you have given? Have you counted?
Rather than paragraph.
Simply say that means 21. You write this 21. Here are 3 more. 21 plus 4. 21 plus 4. How much? Huh?
1 plus 4.
21 plus 3, 24. This is different? 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13. Plus 14. 38 only. You counter. Make submission against this. Para. To buttress his submissions, Mr. Muri has relied upon the following decisions 1 to 30. The respondent authorities have contested the case by filing an affidavit in opposition initially, first of, subsequently, an additional affidavit in opposition initially on 3/9/2020. Also, subsequently on 30/11/2022. An additional affidavit has been filed by the respondent authorities to bring on record the results of the Assam Rifles Recruitment Rally 2012 technical conducted at Dimapur, Nagaland. The pleadings also include an affidavit in reply to the affidavit in opposition filed by the respondent, from the petitioner to the affidavit in opposition filed by the respondent number 9. Two affidavits in reply. Two affidavits in reply. First. The dispute lies on a short compass. First. In that, whether the performance of the petitioner in the Assam Rifles Recruitment Rally 2012 technical held conducted at Dimapur for the trade ORL for the post POS, yes, against scheduled tribe category for the post ORL trade. Was could have been declared as low on merit, as mentioned in the impugned letter dated 22/7/2016. Before deliberating on the dilating on the issue, it appears appropriate to refer to the scheme for recruitment of constables in central police forces, which was stated to have followed in the Assam Rifles Recruitment Rally 2012 technical held at Dimapur, Nagaland, right? The said fact is also evident from the letter of the Ministry of Home Affairs, Government of India, under issued under U full stop O full stop number is 20. Affidavit in opposition is 22, 26/6/2009. (25/6). To stop as per a scheme devised, comma, for recruitment, comma, in the scheme for recruitment, comma, the eligibility for appointment have been laid down. Full stop. The age limit, comma, minimum educational qualification and physical standards are found mentioned in a said scheme for recruitment. Full stop. As per the said scheme, comma, vacancies in a recruitment year are to be calculated annually within bracket calendar year basis. And the recruitment process is to be completed before the end of the year. Full stop. Allotment of vacancies is done on the basis of population ratio. Full stop. Reservations for SC stroke, ST stroke, OBC stroke, ex-servicemen and other categories of personnel are to be in accordance with the instructions issued by the government from time to time. Full stop. Subtitle. As per the recruitment procedure laid down therein, comma, page 27 of the written opposition. The following provisions are found of relevance, and accordingly, the same are quoted here in the page 27 and 27. In the Assam Rifles Recruitment Rally 2012 Technicals conducted at Dimapur, Nagaland for vacancies in the post ORL trade, comma, a total of 25 vacancies within bracket, general 12 and scheduled tribe 13, bracket close, were allotted to the state of Nagaland. Full stop. After completing the recruitment rally, which consisted of height test, recording of biometrics, examination of testimonials, physical standard test, PST, physical efficiency test, PET, written examination, and medical examination, the respondent authorities prepared a select lists of 25 candidates against the vacancies for the post trade ORL, and the said select list consisted of names of 12 candidates from the general category and 13 candidates from the scheduled tribe category. Post of the this board the relevant experts of the select list relating to the 13 selected category candidates from the ST category are as follows. First of, the respondent authorities have also placed on record a list of candidates who secured marks lesser than the last of the selected candidates. Full stop. Of 25 candidates. 25. The name of the petitioner figured at serial number 8 of the said list containing the names of 25 candidates. Full stop. The relevant excerpts of the said list up to serial number 8 are extracted herein. The it is true that the petitioner got qualified at all the stages of the recruitment rally, including medical examination. Full stop. The written test consisted of 100 marks containing at least 100 questions. Full stop. The written test, the purpose of the written test is to assess the general awareness stroke, general knowledge, comma, knowledge of elementary mathematics, comma, analytical aptitude and ability to observe and distinguish patterns based on meaning, and to test the basic knowledge of the candidates in English stroke Hindi. As per the scheme of recruitment, comma, the merit list in each category, namely general, SC, ST, OBC, and ex-servicemen, are to be drawn separately in respect of each state on the basis of aggregate marks obtained in the written test. Close stop. In case of tie in marks, the candidates with older age is to be treated at a higher position in the merit list. Close stop. The final selection of the candidates is to be made in order of merit in each category. And the cutoff percentage of marks per appointment are general and ex-servicemen equal to 35%, and ST stroke ST, SC stroke ST stroke OBC equal to 33%. Just because the petitioner has secured 44 marks in the written examination, the same would not was not enough for the petitioner to get included in the final select list for scheduled tribes of 13 candidates for the post in trade, ORL. Full stop. The last of the selected candidates in those 13 in the list of those 13 candidates secured nine marks. Full stop. Even though the next candidate also secured 49 marks, comma, he was not included among the selected candidate because his age, because the age of the last selected candidate was more than him. Close to. The petitioner was at 8th position below the last of the selected candidates. Conspicuously, comma, while laying challenge against his non-selection in this petition, comma, the petitioner did not impede any of the 7 candidates above him. Candidates who secured more marks than the petitioner and below above the petition secured more marks. The scheme of recruitment has laid down that vacancies in a recruitment year will be calculated annually. And during the year, comma, the number of vacancies allotted for the post ORL trade for the state of Nagaland was 25, out of which 13 vacancies were earmarked for candidates belonging to ST category. Though a contention has been advanced by the learned counsel for the petitioner that the petitioner was medically examined after having qualified in the written examination, the claim of the petition cannot be treated as extinguished. The said contention after consideration, is found unmerited. Insofar as the contention advanced regarding the ratio to be maintained for medical examination, it is noticed that the number of candidates to be examined should be equal to the number of vacancies, increased by average failure rate during medical examination, and the same is to be determined on the basis of past experience. Thus, it is the respondent authorities are in the best position to know about the average failure rate during the medical examination in the past. Merely because medical examination of the candidates, of those candidates who were qualified in the written examination are done, the same does not create any indivisible right on the candidates, in favor of the candidates, to claim appointment. It is an undisputed position that the petitioner had obtained lesser marks than lesser marks within bracket 44 marks. Then the last of the selected candidates, who secured 49 marks, against the 12th number of vacancies under the scheduled tribe category. And it was because of the said region, the petitioner was informed by the impugned letter dated 22/7/2016 that he was found, quote unquote, low in merit against the vacancies allotted for the state of Nagaland. It is too settled in law that merely qualification, merely passing all the stages in the recruitment process does not create any rights to be appointed. First of, it is not the case of the petitioner that the respondent authorities had appointed any candidates against the vacancies in the post trade ORL who had secured lesser marks than the petition to bring in to invoke the to stake any claim for his appointment. On the ground that he has been treated discriminatorily with discrimination. Post of para. In view of such fact situation obtained in the case, comma, there appears no necessity to discuss the principles laid down or discuss the decisions referred to by the learned counsel for the petitioners, aforementioned decisions referred to by the learned counsel for the petitioners. First, as the petitioner has not been able to made out has failed to make out any case for his selection and appointment against the 13 number of vacancies in the post ORL trade allotted to the scheduled drug category to the state of Nagaland. This petition is found bereft of any merit, and the same is liable to be dismissed. It is accordingly ordered. There shall, however, be no order as to cost. Full stop. In any view of the matter, comma, the petitioner is found to approach the court with much delay and laches. And full stop. In addition, comma, the petitioner is found to have not implemented any of the 7 candidates who secured higher marks than the petitioner in the Assam Rifles Recruitment Rally 2012 technical held at Dimapur, Nagaland. First of, the petition is also deserved to be dismissed on those counts. Yes.
Selected 20 candidates, 3 candidates belong to general category, were appointed against a reserve.
Pleaded case. Pleaded case. Pleaded case.
Yes.
Pleaded case.
Let's reply in the respondent number 10, 89. I'm just indicating that.
Which one?
Respondent number 10, 89. They belong to general category.
After, at the end of the hearing, Mr. Muri, learned counsel for the petition, has further contended that 3 of the candidates selected against the ST category. Yes. That is just something.
3 candidates, general candidates, were appointed against the ST reserve category.
How? Show me for the list. Otherwise, I'll impose cost.
My lord, if you look
Unnecessary submission.
at my lord, can you see?
Show me from the document. Show me from the document selected list. No, select list.
page 4, my lord.
I am at page 4.
Yes, error number 13. And what is the reply?
Hmm.
We can verify.
Hmm.
Error number 21.
Hmm.
Page 4.
Hmm. Hmm. Mr. Muri, you challenge those caste certificates. They have produced caste certificate. You challenge those caste certificates. Contention is not required to be.
Supreme Court very clearly says. my lord,
Supreme Court what says? I have seen your 30 judgments. Now tell me more 50. Ah.
One ST from another state cannot be may not be ST in another state. That is what Supreme Court says. So this person, my lord, so my lord.
Sir, this is not Nagaland government.
I understood, madam. These posts are specifically reserved for ST.
Allotted.
From Nagaland, madam. No other.
No, where your pleaded case?
Madam, that we have just improve our version, madam.
Improve.
Madam, in the reply, madam, because only after filing this affidavit, we came to know, madam, all this issue, madam. That's why I'm just indicating, madam.
So, Maurice. Hajurgia can be ST. For your kind information. Hajurgia can also be ST. Right?
I'm not denying that.
They belong to ST. Now, this is Assam Rifles Rally. Otherwise, it is all India.
Yes.
Vacancies are allotted to state of Nagaland. And vacancies are not reserved for please, Mr. Muri, it is Assam Rifles, not government of Nagaland.
Correct.
Right? There is a distinction.
This is correct. But
Right.
what I
And vacancies are allotted to the state of Nagaland. Now that does not boil down to a situation that vacancies are to be filled up by the Nagaland people.
reserve category, madam. That was otherwise general category. Out those
You go on improving if you have pleaded. This is much more. And your petition is otherwise to be dismissed. Because non-implement of all the candidates who secured higher marks than you.
Problem is, my lord, even though they, in spite of court order, they cannot.
No,
produce
you have
report.
implemented, but
No report, my lord, handicap, my lord. They are handicapped, my lord.
but you were also sleeping till 2018.
My lordship,
You were sleeping, Mr. Muri, from 2012, you were sleeping, right? You wake up from deep slumber in 2018. And by that time, you were unfit.
I choose the wrong forum.
You were unfit.
Second.
Yes, Mr. Joe, what to do? Mr. Not possible, already 5 o'clock.
That item.
I'm sorry, I could not, huh?
Item 22 be adjourned, my lord. Last item 22.
Some other day, after the
My
vacation.
lord, next, I have to understand the strength. Lord, I appreciate it.
Okay. Due to paucity of time, Mr. Joe Learned Counsel for a petition and Mr. who is for the respondent otherwise. Mr. Santiago, you were there? Okay. Due to paucity of time. No. As for Mr. Joe.
My case.
Moa Imchen. A Joe Learned Counsel for a petition and Moa Imchen and State Council is the case. Any specific that you want?
After.
Immediately. Is the case immediately after the ensuing winter vacation and a date to be fixed by the office.
March.
Same. Who is the state council? Otherwise, in your case? Huh? Okay, same. Younger Bhati. Item 19. In your winter, central government council. Immediately. The interim order passed, shall continue till the next.